Please, Your Lordship. Your Lordship, I'd like to mention a fresh writ petition which I filed yesterday for listing on Wednesday, Your Lordship. Highly obliged, Your Lordship.
Lord, on urgent matter, my Lord, may I pray for listing today itself, my Lord?
Today not possible.
Then, my Lord, Tuesday, my Lord. Deep
No,
Lords.
Secretary, Lordship, I mentioned to for listing Lordship WBC 5453 Lordship 2023. After 2 weeks. Deep Lord.
My Lord, like to mention writ petitions, two writ petitions against dismissal. They have already been filed for orders on Wednesday. Obliged.
May it pleases you, Lordship. Taking counsel of the other side, Your Lordship, I beg to mention item number 29 of daily list. Here we need to file our affidavit in opposition. Kindly grant us 2 weeks
Fair
time.
learned counsel for the respondent made with the consent of the other side. This matter stands adjourned for 3 weeks so as to enable the respondents to file counter affidavit. List of
Deeply obliged.
May it please your lordships. With the consent of the other side, I beg to mention item number 19 of the daily list, your lordships. The conducting counsel, Mr. K. Mohammed, is having some difficulty today. If it is not inconvenient to your lordships, can it be taken up after 2 weeks? Can it be taken up after 2 weeks?
Item 19.
Yes, your lordships.
You write as paid for by the petitioner's counsel. This matter stands adjourned for 2 weeks.
Deeply obliged.
May it please your Lordship, I beg to mention for listing of a writ petition for orders next week, Your Lordship.
What order?
Lordship, at the matters of 2022, but no affidavit has been filed by the respondents till date, Your Lordship.
After 2 weeks.
After 2. Lordship, with the consent of other side, I beg to mention item number 1 and 2, Lordship. In both the matters, water resources needs to file their affidavit. Lordship. Kindly after 2 weeks, Lordship.
I am the petitioner of the
Item
item
one.
number 1, Lordship. We had no.
And who's the petitioner in item 2?
Item 2, yeah, but they have given consent, Lordship.
With the consent of learned counsel for the petitioner, Miss Jessie Gogoi, learned SC Water Resources Department 6, posting of these matters again after 2 weeks, so as to enable her to obtain instruction and file affidavit. Prayer allowed, list accordingly. Same order in item 1 and 2.
Applies, Lordship.
May I please your Lordship? Lordship, I am paying for listing one writ petition for admission. Lordship, next week, any day.
After 2 weeks. After
Nice.
2 weeks.
May it please your Lordship. Lordship, I also pray for listing of.
After 2 weeks.
Lordship, the thing is a bit urgency because the petitioners, their salaries are held up, Lordship. And it has to come for orders, Lordship, because on the last occasion it was on August. They took time for filing of affidavits, but it has not come.
After 2 weeks.
Deeply.
May I please, Your Lordship? Your Lordship, I have two earnest prayers, Your Lordship. Your Lordship, I'm praying for a listing of a motion matter, Your Lordship. We have filed it yesterday, Your Lordship. There is an urgency, Your Lordship. We have challenged the very order which has been imposed upon us, punishment orders, withholding to the annual service increment with cumulative effect, Your Lordship. And the other matter, Your Lordship, is for orders, Your Lordship, compassionate appointment. Your Lordship may fix a date, Your Lordship.
No, what is the urgency in these cases?
Your Lordship, in this matter, Your Lordship, since we have challenged the very punishment.
Is it your personal urgency or the urgency in the case?
Urgency, there is urgency of the
There is no
petitioner.
urgency in these 2 cases. You are just mentioning because somebody has asked you to go and mention.
No, Your Lordship, the petitioner has insisted upon it, Your Lordship.
Rejected. We allow only matters where there is urgency, not because petitioner wants. Every petitioner wants the case to be heard early. We can't make a pick and choose in these matters.
Much obliged, Your Lordship.
Daily list promotion item 3.
Here, my Lord, challenging the selection of private respondent, my Lord, I filed a writ petition. Honorable Court directed to file an appeal within 1 week, my Lord. Petitioner failed to file the petition within 1 week, my Lord. But we filed second writ petition for extension of the time. Honorable Court, my Lord, hold opinion to file a miscase. I also took time on that day to take instruction in this regard. In the meantime, my Lord, appointment letter has been issued. So against the date of appointment letter, my Lord, under executive instruction 162C, we have already filed appeal before the ZAD, my Lord.
All right, we'll close it then. Mr. B. Raman, and counsel for the petitioner, submit that during the pendency of this writ petition, order of appointment has already been issued in favor of the private respondent, and the petitioner also challenged the same by filing an appeal under Rule 162, bracket C, bracket close of the executive instructions. Therefore, this matter be closed by granting liberty to the petitioner to pursue the appeal Mr. J.K. Goswami, learned additional senior government advocate Assam.
3, 4 and 5 Lords.
S. Datta, learned SC, Revenue Department Assam, and Mr. S. Alam, learned counsel for the private respondent are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands closed with the liberty as by granting the liberty as spread.
File developed.
Item 4.
May please lordship. My lord, without assigning any reason, my lord, opinion has been passed that could not produce any age proof certificate. In persons of advertisement, all criteria is completed, madam, but without any assigning any reason, madam. Comment has been passed that age proof certificate has not been, but at the time of application, age proof was there, madam. School certificate is there.
We will have to issue notice.
Lordship.
Or Mr. B. Islam, learned counsel for the petitioner. Being aggrieved by the remarks dated 12/4/2023, whereby the age criteria of the petitioner, age criteria applicable to the petitioner has been wrongly applied. The instant writ petition has been filed. Mr. Islam submits that unless the impugned remark is interfered with, the same would cause serious prejudice to the interest of the petitioner. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respondents,
Holders.
pray for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Goswami has accepted notice for all the respondents, no formal notice extra copy. Yes.
Item 5.
May it please, my lord. My lord, may I request that this matter may be taken up along with item number 11, as it's based on the same set of facts.
Item 6.
Lordship, I had earlier opposed this honorable court. Your lordship's order is at page 45. The relevant portion is at page 46.
You are challenging the appointment of private respondent as Gram.
Now he has expired, lordship, and lordship, he has already expired.
Who has expired?
The selected candidate. I have annexed the lordship's death certificate at page 47.
So now what do you want?
Lordship, my ground of challenge is that, lordship, I was a son of a Gaon Pradhan, and lordship, I also worked as a in charge Gaon Pradhan on 2 occasions. And lordship, there are criminal cases pending, 2 criminal cases pending. So he was not a person of high status. So that was my ground in earlier.
That's right, but this
Now-
petition has now become infractions.
Lordship, because lordship, I have challenged his selection during his lifetime, lordship.
But that's correct. But
Now the appeal is pending, lordship.
no, Mr. Das, you are not understanding the question. You have challenged the selection of the private respondent
Lordship.
on whatever grounds. You preferred an appeal also. But he has expired, so he cannot be appointed.
He cannot be appointed.
Then what remains in this proceeding?
Lordship, my appeal has not been disposed of, lordship.
Appeal, what is there to be disposed of in the appeal? Appeal has become infractious.
Lordship, the appeal is still pending before the GAD. lordship.
Oh, if you do not want to understand the question of the court, you can't do these things here. I am asking you a straight question.
Lordship,
Your challenge is to the selection of private respondent. He has expired.
he has expired.
So therefore, now it is up to them what they want to do.
Lordship, I am also seeking appointment, lordship, my appointment, lordship.
Where is the prayer? Where is the prayer?
Lordship.
Where is your prayer?
Lordship, page 15, lordship.
Yes. Which part of page 15?
Page 16, a writ of mandamus for a direction to the respondents to appoint the petitioner as ground pradhan in respect of charge number 3, Moza Senga under Senga Revenue Circle, after disposing of the appeal strictly in terms of the guiding principle notified by advertisement dated 3/9/2022, as there is now no impediment since the recommended candidate has already expired.
So what is your stand, Mr. Mr. Datta? Yes, selected candidate has expired. What do you
Expired.
propose to do?
Lordship, maybe some other person is getting more marks than the petitioner. Otherwise, entire allegation is against the private respondent. He is expired. There is no cause of action in this petition.
No, but maybe will not do. You have to
Lordship.
give us definite, we obtain instruction.
Lord- Lord-
Heard Mr. S.K. Daslan counsel for the petitioner. There is the amendments made in the writ petition. This writ petition has been filed assailing the no, you're right. The petitioner had participated in the process for selection and appointment of Gaon Pradhan in respect of charge number 3, Moza Chenga, under Chengla Revenue Circle in the district of Borpeta. Earlier, pursuant to the selection process, what is the name of the person who was selected?
Mokbul Hussain, Lordship. Mokbul Hussain.
Mokbul Hussain, record since this is was selected and appointed as Gaon
Not
Pradhan.
appointed.
No,
Lordship.
selected
Only
for appointment in the post of Gaon Pradhan. The petitioner had preferred an appeal against his selection before the appellate authority. However, during the pendency of the appeal, Mokbul Hussain expired. As such, the present writ petition has been filed with a prayer to direct the respondents to appoint the petitioner in the post of Gaon Pradhan. Mr. S. Datta, Land Standing Council, PNRD, Revenue Department, Assam submits that there could be other candidates in the merit list scoring higher marks than the petitioner, and therefore he be granted 2 weeks' time to seek instruction in the matter. Similar is the stand of Mr. J.P. Goswami, Learned Additional Senior Government Advocate Assam, and Mr. A. Phukan, Learned Standing Council, GAD Assam. In view of the above, this matter be listed again for motion after 2 weeks. One extra copy of the writ petition be furnished to each of the Learned Standing Council so as to enable them to obtain instruction.
May please, Lordship. Now, this is a matter pertaining to departmental proceeding. The petitioner, he was a sub-inspector in Railway Protection Force, my lord. A departmental proceeding was initiated and thereafter inquiry was held. A minor penalty of, my lord, reduction of pay was imposed. Thereafter, my lord, the revisional authority did suo motu revision of the penalty and imposed major penalty of compulsory retirement. My lord, I have challenged the impugn orders on the ground of perversity, my lord. What happened in this matter? My lord, he was detailed for a inspection check in a diesel shed.
Where is the order?
Appellate authorities order, your lordship will find page 107.
No, original.
Disciplinary authorities order, your lordship will find page 78. And relevant portion, page 83, the penalty imposed.
Yes, and where is the appellate authority?
And then in the next page,
Who had preferred the appeal? Your
No.
client had preferred the appeal.
yes, my lord. Initially, they did the suo motu revision, revised the penalty to compulsory retirement. Against that, the petitioner preferred an appeal, and the appellate authorities ordered, your lordship will find page 107. Absolutely cryptic, nothing in there.
And where is the order of the revisional authority?
The revisional authorities ordered, your lordship will find page 91, my lord. And
So, can the revisional authority suo motu enhance the penalty?
Lordship.
What is the law on this?
my lord, the provision is there. Provision is there that revisional authority can do the suo motu revision, but he has to assign reasons on what grounds he is proposing to revise. There is no reason assigned in the show cause notice or the order imposing penalty by the revisional authority. At the same time, the appellate authority's order is also absolutely cryptic, nothing, my lord.
So, this order has been given effect to this March 2023.
Yes.
Yes.
Already given effect to. Then we'll have to issue notice.
Issue notice, my lord.
Or Mr. H.K. Rajani Council appearing for the writ petition. Assailing the order dated 17/3/2023 passed by the reviewing authority, revisional authority, so moto enhancing the penalty imposed upon the petitioner by the disciplinary authority and sending him for on compulsory retirement, as well as the subsequent order passed by the appellate authority rejecting the appeal filed by the petitioner. The instant resolution has been filed in India contending that the orders passed by the divisional authority as well as the appellate authority are not only cryptic but perverse in the eye of law and hence is liable to be set aside by this court. Mr. S.S. Roy, learned
CGC.
CGC appearing for the
Always.
On the
for the
respondent.
respondents has sought 4 weeks' time to obtain instruction in the matter. In view of the above, issue notice of motion returnable on 20th of December 2023. Since Mr. Roy has appeared in accepted notice for all the respondents, no formal notice is required to send in this case. Extra copies of the writ petition be furnished to the learned CGC so as to enable him to obtain instruction and file affidavit.
But I have,
Before the returnable date.
Lord, I have also challenged the order of the disciplinary authority, my lord, along with revisional and appellate, my lord.
Internally assailing the.
Yes. Order dated, my lord, 17/9/2022. Much of it.
Item 8.
May it please your lordship. My lord, petitioner was not given promotion as per his seniority, my lord. Due to lacking of SCR.
Then we'll have to issue notice, heard Mrs. Boral and counsel for the petitioner. The writ petitioner is aggrieved due to deprivation. Due to the fact that he has been deprived of promotional benefit despite being eligible for the same. Mr. G. Pegu, learned CGC, appearing for the all the respondents. Raised for 6 weeks' time to obtain instruction in the matter. And in 6 weeks, since Mr. Pegu has accepted, but he नहीं किया वो.
Item 9.
My lord, may I please, my lord, this is also with regard to the promotion, my lord. Here your lordship will find respondent number 6, my lord. 5. She was appointed as my lord translator. In fact, rule has not provided for promotion of the translators, my lord.
Petitioner is serving in which department?
My lord, public relation and
Assam Information and Public Relation Department.
She's the
So-
journalist, my lord, journalist in the cadre of,
So he's been denied promotion.
yes, my.
We'll have to issue notice at this.
No,
Or Mr. J. Patna, counsel for the petitioner, there is the amendments made in the petition. The case of the petitioner is that although he was eligible for promotion, he has been illegally denied the benefit of promotion. Mr. J. K. Goswami, learned additional senior government advocate Assam, has prayed for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Goswami has accepted notice for respondent numbers 1 and 2. No formal notice is required to send to receive respondent. Extra copies of the writ petitioner be furnished to the learned departmental counsel, learned government advocate, so as to enable him to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 3, 4, and 5 by registered post with AD within a week from today.
Item 10.
They are a private respondent or his junior.
No, but they are in the same cadre, same post. Some of them are in fact not eligible to be promoted because there are some cadres, my lord, most.
At a line denied promotion, although some ineligible candidates have been
Yes.
promoted to the next higher rank. Ineligible candidates from the same cadre had been promoted to the next higher rank. Yes.
Yes.
Maybe the lawsuit, the case of the petitioner is there. In the year 2010, the Excise Department issued advertisement for recruitment of Excise Constable. But petitioners appear before the interview and they clarified. But who RTI, they came to know that some anomalous has been taken place in the recruitment process. After that, they opposed this court by way of a writ petition. The honorable court might order it 14/6/2018 set aside the appointment of the illegal appointees by termination order, Lordship. After that, the illegal appointee approached the writ appeal, they filed two writ appeal, that also dismissed, Lordship. After that, the petitioner, Lordship, files
So the department has not taken any action for what? For appointing you?
no, Lordship, on the basis of the order, Lordship. On basis of the order.
No, but then it is a question of contempt. How can you file another writ petition?
So we filed some revision, so we approached,
Sorry?
we filed some revision in this regards.
No, you can't do it. The law is very different here.
Lordship.
If the court has passed an order and they have not complied with, you have to file a contempt, not another writ petition.
We filed some application to requite us also. For that, I approached.
No, it's not maintainable. You check up the law and come back. Second writ petition with the same relief is not maintainable.
We are not challenging the appointment, Lordship, only.
All right, there is a direction issued by the court
Lordship.
to take action in your case. Is it not?
Yes, sir.
No action has been taken.
Second.
So you have come again to issue another direction to take action.
Only for disposal of the representation. To comply.
That's not a substantive relief. That's a relief molded by the court. That's not a, you check up and see what is
Fix
the.
another day. Lordship.
Mr. N. J. Govil, on counsel for the late petitioner, pays for and is granted a week's time to examine the question of maintainability of the writ petition and address this writ petition. Mr. C.K.S. Burrell and Government Advocate Assam is present on behalf of this case. Just the matter accordingly. Have you understood what I've said?
No, I understood.
There are 2-3 decisions of
Okay.
this court. also.
Contempt is there, contempt maybe.
You have to know
Okay.
these things. If I don't point out, you will never know. We'll
Okay.
keep doing the same things.
Highly obvious.
Item 11 along with item 5.
Wait, please, my lords. My lords, in both the matters, the petitioners are working as honorary chairman under the Morrigaon Revenue Circle, my lord. Being eligible, my lord, the Deputy Commissioner Morrigaon had recommended both of them for undergoing the recorders training at the training institute, my lord. However, my lord, when the same was not taken up, one of the petitioners in item 5 had done RTI application, pursuant to which it came to know that one of the recommended candidates was incorporated into the course of 2014. However, they were excluded. Thereafter, they made a representation, however, that was not acted upon. Thereafter, my lord, between 2015 to 2022, my lord, 2 writ petitions and 1 contempt petition followed, my lord, pursuant to which the petitioners were finally admitted into the course, which they duly completed in the year 2023, my lord. However, in the meantime, the petitioner in item 5 has crossed the age, my lord, maximum prescribed age of 40 years. And therefore, my lord, the present petition has been filed praying for a direction to the respondent authorities to consider his case for age relaxation as is permissible under the rules of 2023, which has recently come into being. And my lord, apart from that, since they have already completed their courses before the coming into effect of the new rules, therefore, my lord, the new rules mandate that after their initial selection, they have to undergo the 6 months recorder's course, which they have already undergone. Therefore, my lord, a direction is also sought to consider the case that they should be exempted from undergoing the training subsequent to their selection. That is the prayer, my lord.
Lordship, from the prayer portion, it is single lordship. It is a premature appeal, lordship. They have come before this court on apprehension that in the event of issuance and advertisement, they may not be called for interview, lordship. Apprehension is.
People are apprehensive what to do.
Lordship.
There are apprehensions.
Lordship.
Not many people are apprehensive
Lordship.
about many things.
Lord,
How can you stop them being apprehensive?
no, that they,
You must be doing something why they are apprehensive.
lordship.
Our petitioners lost 12 years of their employable
Then-
age because of the litigation.
Where will they go? What will they do? You have to
They-
look into their problems.
Lordship, otherwise for age relaxation, there is a notification issued by the government 1951 that is in force, lordship. They may apply before the
My lord,
authority and they have considered.
my lord, we have already
You
preferred
obtain written instruction, we'll
Lordship,
dispose
lordship.
it of accordingly.
Lordship. Then
After 2 weeks for motion,
Lordship.
my lord, may I request, my lord, we have already preferred a representation which is annexed 19/2020 My lord, the last page.
1923, yes.
Yes, 1/9/2023. My lord, the pendency of this writ petition shall not be a bar for them to consider our representations in light of the
Just
2023.
Obtain written instruction
My
will
lord.
dispose it of.
My lord.
Mr. A. Purval, counsel for the writ petitioners in both these writ petitions. Peruse the amendments made in the writ petitions. In the respective writ petitions. The grievance expressed by both the petitioners are of similar nature.
My lord, in the second writ petition, the petitioner is not overage.
Yeah,
However, he is seeking for a consideration for his appointment.
35 is now.
On an apprehension that the petitioners may not be regularly appointed as chainmen.
As Lat Mondal / land record assistant.
Lot Monroe / land record assistants. On the ground that they are either overaged or have not undergone the RCCC.
My lord,
Article C, yes.
my lord, both of them have undergone
They're
the
qualified.
training.
Hmm.
But under the new rules, after the selection, they have to go the mandatory 6 months training.
Either overaged or have not completed the training as mandated by the new set of rules. The instant writ petition has been filed. Mr. Datta, Learned Standing Council, Revenue Department, Assam, 6 posting of these matters again after two weeks, so as to enable him to obtain written instruction responding to the apprehensions expressed in the writ petition. Prayer allowed. Petitioners counsel to furnish 1 extra copy of each of both the writ petitions to Mr. Datta within 3 days from today, so as to enable him to obtain instruction. Mr. J.K. Goswami, the additional senior government advocate Assam, is present on behalf of the state. Let these matters be listed for motion again after 2 weeks.
I'm obliged.
You get a written instruction and we'll
Lordship,
dispose it of.
I'm so
Otherwise, we'll have to file affidavit.
Obliged.
Item 12.
Lordship, petitioners before Lordship has have participated in a selection process initiated by Staff Selection Commission in the year 2018 Lordship. And they are OBC categories. They scored Lordship the more marks than the unreserved candidate. Lordship, they have not been appointed Lordship. And Lordship, this matter is otherwise covered matter Lordship. Lordship, the covered case is at page Lordship 62.
Is that what OBC category relaxation?
Yes, Lordship.
Yes, my lord, that is.
Kali, how many petitioners?
There are
Two petitioner Lordship.
2 petitioners.
My lord,
OBC.
I have a small prayer, my lord, and that is the covered case, but my lord, one line may be added, that is that as per their merits against the available vacant post, my lord.
No, that part yesterday we have dealt with.
Yes, sir.
The question of selection will not, appointment will not arise without merit.
Yes, my lord.
So if you say that they are not eligible
Yes,
otherwise, then it is a different thing.
yes, my lord.
Otherwise, there is no question.
Yes,
And we have held that if the posts are not, vacancies are not available,
Yeah.
supernumerary post is to be created. Because if they are selected, you have to appoint them. If the criteria used is wrong,
yes,
you have given appointments to general category scoring lesser mark and reserve category scoring higher mark, you have not appointed. You have to appoint them. There is no way out. The criteria is wrong. This is a relaxation provided under the statute for reserve category. And that is another relaxation due to the features of the individual. You can't equate the two. We say,
As to the Lordship.
dispose of Kali order.
Obliged Lordship.
13.
May I please? I don't have any commissioner appointment, my lord. Commissioner appointment, my lord. DLC recommended my name. Lordship will find the page 61.
62.
DLC recommended.
My lord.
And SLC?
That part is not visible from his petition.
Now, my lord, it is pending me for SLC, my lord.
When DLC recommended, when?
My lord, page 60, my lord,
Page 1/7/2022.
on 7/22.
All right, we'll issue notice at this state. Has Mr. Mr. A.K. Azad, my counsel for the petitioner. There is the amendments made in the petition. The petitioner had applied for appointment on compassionate ground after the premature demise of his father, who died on 19/1/2012, who died in harness on 19/1/2012. The DLC has recommended the case of the petitioner. However, the grievance of the petitioner is that the SLC has not taken a decision in the matter till today. Mr. C.K.S. Borwal, learned government advocate Assam, appearing for the
2 and 3.
response numbers 2 and 3. And Miss P.S. Neo
For respondent number one,
for
four,
learned
five.
SC Irrigation Department for response numbers 1,
4, 5, and 6.
4, 5, and 6 have both prayed for 6 weeks time to obtain instruction in the matter. Prayer allowed. NOM 6 weeks, since the respondents are already represented, no formal notice. Extra copies be furnished to the learned department council.
Item 14.
May I please? My lord, this is regarding my lord appointment of my lord Jolo Mitra under the my lord Jolo Jeevan Mission scheme. Now lordship kindly see page 73. The my lord important selection.
So what is this? So many cases are coming, people are donating land and then they want an appointment. Is it happening? Are you accepting the land donated by the petitioners? Is there any promise made to them?
My lord, that will have to verify.
No, but it appears there is a pattern here. So many cases have come.
Yes, my lord.
This is completely impermissible. You tell us what is happening. We'll institute an inquiry into the whole thing. Heard Mr. M. Mondal and counsel for the petitioner, peruse the averments made in the writ petition. The petitioner claims to be the donor of a plot of land which was used for the purpose of setting up the water supply scheme, bracket, house of JJM, bracket close, at Kadamtola in the district of Dhubri, on the promise that he would be appointed as Jalamitra. However, since no order of appointment has been issued till today, the petitioner has approached this court by filing the instant writ petition. Mr. A. Borua, learned SC PhD Department Assam, and Mr. C.K.S. Borua, learned Government Advocate Assam, have both prayed for some time to obtain instruction in the matter. NOM 4 weeks. Who is appearing for whom? Mr. Borua?
My lord, I appear for respondents 2 to 4, 8 and 9.
So I'm appearing for 1, 6.
1 minute, 1 minute. Since Mr. C.K.S. Borua and Jia Assam has accepted notice on behalf of respond numbers
1, 6, 7, 10, and 11.
and Mr. A. Borua, learned is SC PhD for response numbers
2, 3, 4, 8 and 9.
No formal notice is required to be sent to the said respondent. 8 and 9.
9.
8 and 9. Huh? Who is for 5?
Deputy Commissioner.
Council are not even aware who they are representing.
District Commissioner.
The chairman is there, the chairman we don't, so notice has to follow, sir. Chairman also.
As such, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition, requisite in numbers, is furnished to the learned department council within a week from today, so as to enable them to obtain instruction. Petitioner takes steps for service of notice upon the remaining respondents.
My lord, till then, my lord,
Till then,
the
what?
respondent number 14 is the own brother of the president. Respondent number 13, who has been my lord
Any
selected.
appointment made during the pendency of the writ petition shall be subject to outcome of the writ petition. But Mr. Mondal, you will, in no such case will the mandamus be issued. This is completely illegal.
But there is a scheme, my lord.
Maybe. That scheme is required to be struck down. How can you give land an appointment in public? Any kind of public office is subject to
Yes.
Article 16.
If it is going, my lord,
Nothing
then
or nothing less.
under Article 49,
So
16.
what we'll do is if any appointment is made,
My
we'll
lord.
club all cases and cancel those.
My lord.
This is wrong scheme.
Right.
It can't be done.
And in that case,
Otherwise, anybody will say, I'll give
Yes.
you 2 cows, give me this, I'll give you this. How can these things be
Yes.
done by the public authorities? But there will be a cost on the people who have done it.
Right.
How these things are being indulged in? We are living in a barter system or what? Huh? It's a medieval Indian system. You give me land, I'll give you appointment. Who is the authority to give all these promises? You file your affidavit, we'll take a view in the matter.
Obligation.
This is not permissible under the constitution. The government cannot do it. Will interfere in these matters at an appropriate stage. Yes.
Item 15.
It's for competition appointment, madam. DLC recommended
Similar to item number 10, Lordship, just now.
13, madam. 13.
Similar to item number
13.
13.
item 13. DLC recommended, but SLC not.
Yes.
Item 13 was same order. List together.
One line may be added, madam. Pendency is not a bar, madam.
They will not do it.
Item 16.
May it please, Your Lordship. Departmental proceedings, my lord, wherein some footage has been shown in some TV channel. The petitioner was the deputy commissioner in Sirang that time, my lord. He was, vigilance case was registered, he was arrested, put behind the bar. Now subsequently investigation has been done. This footage, the raw footage was obtained and FSL report was obtained genuine. Then charges was submitted, my lord, and in that particular case, my lord, the trial court himself observed the footage. In the footage, it shows money was offered, he pushed the money away and the money was missing, and thereby all along he was working. He never accepted that, and he was discharged from the case. On the same facts, my lord, on that particular footage, show cause notice was issued. I asked for the documents. This footage was never been supplied. Asked for the witnesses, never been given, my lord. I retired in 2018 itself, my lord. And thereafter, my lord, inquiry officer came with a report that nothing has been found against me. Same is sent to the disciplinary authority. Note of disagreement has been there in 2019. And to that effect, I asked to file a representation, that's all. No opportunity of nothing. From 19 to 2023, 5 years, my lord. No pension. Nothing. I am praying, my lord, with my this one, my lord. That disagreement, dissenting note, my lord, doesn't have reasons also. In that view of the matter, I am praying before this honorable court to, at interim, my lord, stay the whole of the departmental proceeding, my.
The departmental proceeding was initiated in 2017.
18 months, yes. 17, I'm sorry. I'm 17. 30/10/2017 was the show cause. In the same footage, my lord.
Any order of penalty?
Nothing, my lord. The inquiry officer found nothing against me. And he sent it to the disciplinary authority. The
So due
note
to
of
the pendency of this proceeding, your pension has been held up.
absolutely, my lord.
Your client retired when?
I have retired from service, my lord, on my lord, 36/2018, my lord. 5 years.
Yes, Mr. Goswami, why his pension has not been
Yes,
settled?
Lordship, kindly accommodate me 1 week time, Lordship. I will bring the instruction, whatever it is, Lordship, and in the entire matter, Lordship. I'll fix the matter in the next
I'll leave it
week,
to you,
Lordship.
Lordship.
Yes.
We'll have it on 4th December. 4th of
4th December.
Heard Mr. A.K. Bhuyan and counsel appearing to the petition, assailing the disciplinary proceeding initiated against the petitioner on the basis of show cause notice dated 30/10/2017 and the consequent inaction on the part of the respondents in concluding the same, thereby resulting into stoppage of pensionary benefits to the petitioner. Mr. Bhuyan submits that his client had retired on 30/6/2018, but till today his pension has not been settled due to the pendency of these proceedings. As such, an interim order be passed suspending further proceeding in the disciplinary inquiry, and a direction be issued to settle the pension of the petitioner. Mr. J.K. Goswami, learned additional senior government advocate, Assam, prays for time till 4/12/2023 to obtain preliminary instruction responding to the allegations made in the writ petition. Prayer aloud. Let this writ petition be listed for motion again on 4/12/2023 so as to enable Mr. Goswami to obtain written instruction with the preliminary response of the department to the prayer made in the writ petition.
Let
two
this-
extra copies. of
May I
the-
pray, my lord, let this matter be listed along with the pension case, my lord, that is writ petition number 7962.
We can pass that order, but Mr. Bhuya, probably it will be better you don't do it.
Yes, let it.
Moment you tag it, it's
Yes.
going to next
Yes,
March.
yes, let it.
Two extra copies will be taken.
Ajay steps. Deeply obliged.
Order for impeachment, item 17.
May please your lordship may kindly pass over this matter for the time being.
No, this is order for implement
Yes,
in WPC.
Lordship, we have objection in this, we have filed our objection, Lordship, and it's on record, Lordship.
Why you want pass over?
Yes, my lord.
Why?
My lord, the conducting counsel in this matter, my lord, is a Lexus courtroom to my lord.
Who is the conducting counsel?
My lord, S. Bot have my lord.
Well, let him come.
My lord.
Yes, Lordship.
Oblige me.
For admission, item 18.
May it please your lordship, my lord, I have filed my affidavit in this matter, but response from the finance department is necessary, my lord, because the regulation matter, my lord.
Yes, madam. Already there was a specific direction, madam. They have not filed a response. Once people peruse the order dated 13/7/2018, madam.
No, but finance department is not even present. They don't appear
Finance.
without any.
Oh, nothing there, right?
Name has been shown. Heard Mr. N. Burwal and counsel appearing for the writ petitioner. Also heard Miss M.D. Boral and standing counsel
WMD department, MD
MD department.
for 1 and 2.
For the respondent numbers 1 and 2 submits that affidavit on behalf of the department has already been filed, but in order to resolve the dispute involved in this writ petition, counter affidavit from the finance department would be necessary. First of all, I find reflection of such a direction in the order passed by this court earlier on.
Is an affidavit delivered?
Passed by this court even on 7/2/2022. However, no affidavit has been filed by the finance department till today. Personal appearance? Who's for the?
Why not, Mr. Kejo is on the.
Then we'll call the officer, secretary.
Any order because it
Huh?
was part of the standing council, madam.
Sorry,
We'll file our affidavit.
whose name should be recorded? You don't seem to know anything.
H. Guru on behalf of Kejo.
Huh?
H. Guru on behalf of Kejo.
He's appearing on behalf of B. Gogoi, my lord.
Mr. B. Gogoi, Learned Standing Council, Finance Department, Assam, prays for 3 weeks further time as last opportunity to file affidavit. Prayer allowed at last chance. It is made clear that if no affidavit is filed within 3 weeks on behalf of the Finance Department, this court will proceed to dispose of this matter on the basis of materials already available.
Deeply obliged, my lord.
This is a case of compassionate appointment. Petitioner's husband died on 28/5/16. And there was, she applied for, she is a signed graduate. She applied for the post in the 3rd grade. And her case was forwarded by the DLC, but the SLC at page 17 has rejected her case, Milon, on the ground that not within the 5% quota. You also will find it at page 18, serial number 40, Gunavati Fukan Hazarika. But under the 15th circular, Milord, OM, now the quota has to be, there is no 5% quota. It is to be on the basis of the direct recruitment's total strength in the cadre. So, since that was not considered, I will submit, Milord, at page 10 of the, at page 12 of my OM, Milord. Oh, no, oh, yes. Your lordship has considered a positive order,
Page-
compassionate appointments,
Page number,
page number 12 in the OA 1433, my lord. There your lordship has passed an order incorporating that to be considered at the time of hearing. Compassionate appointments shall be made only in the grade 3 and grade 4 posts against vacancies under the direct recruitment quota.
which page of the IA is the relevant part?
Page 12, my lord. Page 12, clause 10.
Yes, so you say that because of this 5% is no longer,
My lord, my lord.
that's difficult to accept. All that this notification says is the vacancies will now be taken into account only for the direct recruitment quota and not the promotional posts, if any. That's all. It doesn't say 5% is done away with.
That is not spoken very clearly.
What is your stand?
My lord, it is always 5%, my lord, for compassion appointment. The rest, my lord, will go for direct recruitment.
So we'll allow his petition then. You have nothing to submit. I don't think you have read the brief also, Mr. Dhar. Off the cup, our arguments will not work.
We haven't filed our affidavit also, my lord, here.
No, you have filed it. Like
No,
running.
I'm talking about.
Oh,
WD.
yeah, I'm sorry. Naikurani, কোন আছে লাগিছিলে? Naikurani কি?
My lord, here it is, their contention is that 16 numbers of poster, 16 number even doesn't make one, my lord. There has to be 20 posts vacant, then only from that one post will be carved out.
You have not filed affidavit.
My lord. My lord, will file our affidavit, my lord. I will file, my lord. Let this matter may come off in the month of December, my lord. In the month of December,
Let it be in January then.
January, my lord.
And Mr. Chaliya Learning Senior Counsel assisted by Mr. Anwar Learning Counsel appearing for the petitioner also heard Mr. Hardhart and a standing counsel PWD department, PWD Assam, who prays for 4 weeks further time to obtain instruction and file affidavit. Prayer allowed on the request of Learned Counsel for both the sides. Let this matter be listed again in the second week of January 2024. But unless these matters are difficult, 5% quota, unless it is shown that there were vacancies available, how does the court issue a writ of mandamus? This will keep your clients coming to court for the rest of our life, but nothing will work out. How the orders will be implemented? I have seen many cases like that. Orders have been passed, appoint.
Before the district committee, my lord, the vacancies are pointed out.
So that is
And
why
on the basis of that, my lord,
many
yes,
cases were grouped together. Are they still there?
Exactly, my lord. Yes, my lord, that is fixed for hearing on December 15th.
So we wanted to see what is the way forward in these matters.
Actually, my lord, what happens, this DLC, they give this, whatever vacancy there is, my lord. They are not the technically sound, my lord. So they don't calculate that 5%. When it goes to SLC, then only they take it out that there is 15 seats. So we cannot take out one seat from here.
So that
Unless there is 20.
DLC recommendations are nothing but false hope. And then SLC dashes this hope, then people come to the High Court. High Court sends the matter back. Then it lies pending for another 3 to 5
my lord,
years.
exactly,
Then some new notifications come.
My lord, exactly. I asked one of my executive engineer, why you send this? They say that, see, these people, they have worked in our office whole their life. We know that they are family. They come to us. What to do? We just recommend. Let the higher up take decision. This is what my lord they do, my lord. They said they have been working in the office for 20 years. We know the family.
So now there is no fresh recommendation.
No. From 2017, my lord, it is the other way, my lord. They will get pension, my lord.
Yes, that is true.
Therefore,
So all these cases will.
prior to my lord 17.
You give pension to all of them then? Prior to 17 also?
No, no, my lord. Prior to 7, we have been giving my lord compassion appointment, my lord. Prior to
No,
17.
you can't say we'll give neither pension nor appointment.
No. Family pension we are giving, my lord.
Prior to 17 also?
Prior to 17 also. Family pension they are getting. Family pension they are getting.
You're getting it.
Family pension is there.
Family pension they are getting.
And what about compassionate pension?
Oh, compassionate.
Compassionate pension is rest of the services, they are given full pay
Full pay after 17, my lord.
up to the date of
But-
retirement.
Up to the date of retirement, my lord, the family will be getting full salary. And thereafter, once that superannuation date is, my lord, attained, then they will go for family pension. Post 2017, my lord. That is the policy of the government, my lord. And before that, my lord, we have both the things. Family pension as well as compassion appointment, 5% quota. Whoever gets in that 5%, they get the job, my lord.
So therefore, two sets of people are they not being discriminated?
But
One set of
that is the
people,
point. That is the point.
regardless of whether they get appointment or not, they are getting compassionate family pension, compassionate pension, which is a higher amount. So whether or not they get the job, they are getting the salary.
My lord, then somebody has to challenge this 2017 OM, my lord. And
That's what this court has been hinting again and again.
and my lord, and maybe, my lord, that person has to be of that stature, man, who hasn't applied for compassion appointment and his case was rejected.
No, if you say that we can't give compassionate appointment, why is this compassionate family pension? Why is this compassionate pension? Because the government doesn't want to give the compassionate appointment, correct? So the question of vacancy is no longer relevant here. If somebody bread earner dies in harness, he applies and he gets compassionate pension. It's a lot simpler. The financial support comes and the job scenario is not disturbed. But why are you drawing a cutoff line between people who died before 17 and people who died after 17? What is the criteria for deciding this? Then you have to give it to everyone.
My lord, prior to that, we have been giving appointments, my lord.
All right. So those who haven't got appointment due to want of vacancies, you have to give them the compassionate pension. But surprisingly, not a single case anybody has raised this point or even argued. I'm extremely surprised. It's just the same thing. Everybody wants 5% vacancy, 5% vacancy. It is coming and going and coming and going. Nothing is happening. People died in 2009, 1999. They are also coming 5% vacancy. Mr. Salia, somebody in the bar should take the lead in these matters. Almost the judges are being asked to argue cases. That is not correct.
That is true.
Otherwise, nothing can be done. There is no, I'm sorry to say, nobody is looking at these things in a. But if a question is raised, then of course now the court has to almost say that file this case. This is what it has come to.
This is, my lord, this is the policy decision of the government, my lord. That has to be, my lord.
Policy decision, can it violate Article 14? Does the government have that power to take a policy decision which violates Article 14? What is the difference between people, just because someone died before 2017, his family will go without anything. And somebody who dies after 17, they will get this benefit. What is the criteria? These policy decisions are contrary to the constitutional provision and can be struck down.
My lord, even this 5% quota, this is also backdoor appointment, my lord. If we.
So, all right, the government, we are not questioning the government's intention. The government may be very justified in taking this pragmatic stand. All we are asking is then, how do you make this distinction? Maybe a pragmatic team of officials or ministers have saw more virtue in this after 2017. That's a good thing. We appreciate. But how can you leave out the others just because the date of policy is 2017?
Yes, my lord. That we left to, my lord.
Article 14 continues from the date of commencement of the Constitution. That is not subject to the policy, date of the policy.
Yes.
That argument has not been made by anyone. Nobody. And there are hundreds of cases on these lines.
But my lord will appreciate also this. We have given thousands of appointments prior to 2017 in this 5% quota to people.
No, Mr. Dhar, you are probably not understanding the question.
I understood well.
Nobody is questioning the government's intent or the benevolence shown here. Nobody is questioning. Even the ingenuity in coming up with a policy is very well taken. All we are saying is, if you leave out those whose bread earners died before a particular
I
date,
understand. Yes, my lord.
only on the ground that the policy was notified on such and such date, are you not violating Article 14? Because some people similarly situated are getting some benefits, some people are not getting those benefits. If it was the case that Article 14 itself was incorporated in the Constitution after 2017, matter was different. But whatever your policy decision, it has to be in consonance with Article 14 and 16. You are giving compassionate pension to some people, not giving it to others. The others, if they get appointment, fine. Majority of them are not getting appointment. Not getting. So they are left high and dry. What we are asking you is, what is your scheme for those who are not getting appointed, despite all other things being in order? So somebody applying within 1 year, recommended by DLC, it turns out later on the vacancy is not available. Are you not giving him nothing? Whereas a similar person is getting the compassionate pension under the scheme only because his bread earner died after 2017? Can a stand like this be accepted in the constitutional scheme? That is the question. It's not about the government's intent.
My lord, let me just
You
come.
are lucky nobody is raising these issues.
Because my lord, everyone's at 5%, my lord. People are aggrieved that we have come up. There are many cases.
We are not concerned who wants one.
My lord.
Who wants what is not our concern.
I understand.
We are only concerned with,
I appreciate. I understand.
do they have any right that can be recognized and to what extent? Nothing more.
I understand.
Wanting, desiring, these are not our job.
My lord.
That is for your executives to decide. We are not going into that. We can't decide those things. Once you take a decision, whether it conforms to the constitutional scheme or not, that's the only thing we'll see.
That is there, my lord. We'll have to address that, my lord. If it comes up, my lord.
Lordship, we have received the FADP in opposition. So please kindly give us 4 weeks time for the reply.
Those are your reading glasses
Yes, your
or
lordship.
sunglasses.
No, lordship.
No, you look good with that. Works like an antenna. What do you want?
Lordship, we want 4 weeks time for the reply.
Your name, please?
Amrita Das. I'm the proxy counsel for Adil Ahmed, sir.
Ms. Amrita Das, appearing as proxy counsel for the petitioner herein, submits that counter affidavit filed by the respondents has been served upon the petitioner only recently, and therefore 4 weeks time be granted to obtain instruction and file rejoinder. Is it? Mr. H. Gupta and CGC is present on behalf of the respondent. On the request of the petitioner's counsel, this matter is adjourned for 4 weeks so as to enable her to file rejoinder.
Okay.
Is there any interim order? Is there any interim order here? No.
No, lordship.
Item 22.
Mayor, please. Pass of the matter, I have to take instruction, your lordship.
Pass over.
Yes.
Pass over means finish it. Are you
No.
suggesting that?
No, in this case, there is a series of compensation and appointment hearing is going on. So this may be taken with this case.
The matters are already being heard.
Lordship, there were three persons, Lordship. Out of them, only one has been recommended, Lordship. And
No.
What do you take?
Anyway, your lordship, pass over for the day.
On the prayer of Mr. Upadhyay, Learned Counsel for the petitioner, this matter stands adjourned for 4 weeks so as to enable him to obtain updated instruction. Mr. C.K.S. Gurwal, any government advocate Assam is present on behalf of the stage. Yes.
May I please, your lordship? My lord, this matter relates to compassionate appointment, my lord. Matter relates to compassionate appointment. My lord, second time filed this petition, my lord. Because my lord, non-consideration of the case of the petitioner, my lord, by the DLC, my lord, as per the government notification, 2015, my lord, personnel department. My lord, in this regard, my lord, our honorable High Court passed an order, my lord, to consider, my lord, shall consider his case, my lord, as per my lord, this 2015 notification and notification's case. But my lord, DLC, my lord, on 27/19, my lord, minutes of the DLC was that, my lord, as the 5% quota is not available in the irrigation department, my lord, government of Assam. So, my lord, it was sent to the administrative department. My lord, now, my lord, humble submission is this, my lord, the deputy commissioner is the head of the chairman of the DLC, my lord. So, he has the ample power to giving the proper consideration any other department as per his educational qualification, my lord. My lord, this is the matter, my lord, in this regard, my lord, from the decision, my lord, any other department, my lord, in our High Court's order, my lord, DLC, all DLCs and SLCs directed to take into account the overall vacancies available in all the department and thereupon consider such vacancies against all the applications.
Yeah, what do you have to say,
My
Mr.
lord?
Goswami?
Lordship.
You seem to be very busy with the,
Lordship, here in this case, Lordship, so far.
so it can be taken up for disposal today?
Lordship, Lordship, I obtained some instructions.
Perhaps it can be, all right.
No, my lord,
Yes, we'll dispose it off.
Yes.
my lord, only administrative department, my lord, give proper instruction to consider our case, my lord. Full pending case, my lord. Earlier also we have filed this petition. Deputy Commissioner, my lord.
Where is the earlier order of the court?
Yes, my lord.
Page,
Page 24, Lordship.
My lord, page 25, paragraph 5, my lord. DLC shall consider his case in terms of 15 of the office memorandum dated 1/6/15 issued by the Department of Personnel Department. In short, the petitioner should be considered against any available vacancy in other departments apart from the irrigation department. Clearly states, my lord, clearly.
Send the proposal to the administrative department. So far, from my instruction, Lordship. After the honorable court order, Lordship, the proposal was
so
sent.
has this case been considered for other departments also?
Yes, it is for humble petition.
So far, Lordship,
Mr. Goswami, you don't have to be prepared in any case. You are just playing with some words.
no, Lordship, here in this case.
Do you have the instructions that we are asking?
Yes, Lordship, yes.
What
I
is-
have the instruction that the matter was sent to the administrative department.
Correct. So
Lordship.
there is an order from the court to consider him for other departments also. Has it been done?
No, the order was passed to considered as per principles 15,
No,
Lordship,
come to
of the
page
OM.
25, the last two.
Yes, Lordship.
In short, the petitioner, please read that. Page 25, last sentence.
In short, the petitioner should be considered against any available vacancy in other department apart from the education department.
Has it been done?
Yes, Lordship. The matter was sent to the administrative department, Lordship. Administrative department will see whether there is any other vacancies in other departments, Lordship. That is the fact.
So has it been sealed?
Yes, Lordship.
Well-
It was sent.
Then what is the outcome?
No, for that count, Lordship, I have to sort the instruction, Lordship. Two 22, last year.
So what is the decision of the administrative?
No, that, for that lordship, I have to take instruction.
Yes, PB Border, yes, yes.
PB border.
Yes, yes, learned counsel appearing for the petitioner. Also had Mr. J.P. Goswami, learned additional senior government advocate Assam appearing for the state, and Mr. P. Upadhyay, and Upadhyay, learned standing counsel.
For 1, 2, and 4, irrigation,
Irrigation department appearing for respond numbers 1,
2 and 4.
2, and 4. Mr. Goswami for respond number. You are appearing for the deputy commissioner also.
I am 1, 3 and 4, sorry.
1, 3, and 4. Mr. Goswami, respond number 2. Mr. Goswami submits that after the matter was referred to the administrative department, what decision was taken on the prayer of the petitioner is not known to him, and therefore he be granted 3 weeks time to obtain written instruction on the matter. In view of the above, let this writ petition be listed again after 4 weeks, so as to enable Mr. Goswami to obtain, enable the learned government advocate Assam to obtain written instruction.
Can you fix it?
After 4 weeks as a fixed.
My lord. Highly obliged.
Item 24.
SLC has rejected because he is only 8 pass.
No.
At least 10 passes is there.
Subsequently, my lord, in the year 2017, I matriculated. I got, or I passed HSC examination, and that certificate was given to the respondent number 9 before recommending the name of the petitioner.
SLC certificate.
And by the order of this honorable court, dated 13/5/2022, it has been reflected.
So when did you apply? When did your client apply?
In the year 2016.
At that time, did you have the qualification?
At the time, I was under matric. Means
That
class
means you
9.
are not qualified.
At the time, not. But subsequently, in the year 2017, I matriculated. Means I passed HSC.
But,
exam.
but your qualification on the date of application will matter, not.
Not
subsequent.
matter. But before recommendation made by the respondent number 9, that is executive engineer, PWD, I passed the matriculation examination, HSC examination, and that examination certificate was given to the dealing assistant of the executive engineer, that is respondent number 9, my lord.
SLC certificate to your
Yes,
page number?
yes, page number 30.
Wait,
36, annexure 8.
This certificate was submitted when?
Yes.
When?
In the year 2017.
I want the date.
That
SLC
probably
certificate can I get? 2 years course of this board.
36, 2000.
Not SLC, no, Assam.
Sanskrit Board.
Madam, exactly, I do not know the date when he submitted the certificate, but he said
No,
to
but
me
then what?
in
is
the year
done?
2017.
No, no, he is, their stand is that you are not qualified on the date of.
One more thing,
application.
Lordship, page number 36, Lordship, the certificate says, it is not SLC certificate. Only 2 years course of this board, only 2 years course. How it can, it is not SLC, page number
Assam
36,
Sanskrit Board.
page number 36, Lordship.
Equivalent to HSC.
Don't make false submission before that.
No, not.
It is not SLC, it is Assam Sanskrit Board. ASB it could be.
Equivalent to HSLC.
Duly passed the Potixa exam, Provisika examination 2017 2 years course of this board and is placed 3rd division.
And what is the minimum qualification?
Class 10, Lordship.
Plus 10. For
Grade 4.
My lord, if my lord goes by page 49 of the writ petition, it is here, my lord, that he is class 8 pass.
Officer, he complete probably question.
So what to do? Your client did not meet the qualification norm on the date of application.
Actually, I am sorry, my lord. In respect of submission of this certificate, the exact date has not been said to me, my lord. And but one thing, after passing out, the examination he submitted in the year 2017. He passed out HSC examination equivalent to 2017, and after getting the
So
certificate.
show us some Sanskrit board 2 years is equivalent to HSLC. Where is the equivalence? Draw it.
In this aspect, I may be given a chance.
All right, on the prayer of Mr. So-and-so learned counsel for the petitioner, made with the consent of Mr. CKS Guru and Mr. R. Learned SC PWD and Mr. CKS Guru Learned Government Advocate Assam. Admission hearing of these matters stands adjourned for 4 weeks, list accordingly.
Date may be fixed, my lord.
Yes, yes, it is fixed.
Item 25.
MS Ali.
But similar cases are pending for review before the honorable court. They have filed a review petition. So may not be.
What is the review petition number?
It relates to the recovery of the after retirement, but this person is retired from service. And by 2020, there is letter that your salary was paid more. So as per the order of the Honorable High Court, my lord, that you cannot recover this earlier salary what has been paid. That has been settled by our own High Court as well as the Supreme Court, my lord.
So there is a review petition pending.
Yes, my lord, review petition number 172 of 2022.
That I have given before your lordship.
No, this is not review petition. This is a writ petition.
Yeah, your lordship will get it, my lord. Review petition regarding.
On the request of Mr. S.C. Vishnu Learned Counsel for the petitioner and Mr. A.K. Datta Learned CGC appearing for the respondents, this matter is directed to be listed again along with review petition number 172 of 2022.
2022, 172 of 2022.
Which is stated to be pending before this court.
Item 26.
Lordship, currently matter for time being.
Can you please use the microphone?
Time being, my lord, is paid.
What is this matter about?
Well, this dismissed, my lord, he was not in duty from several times, my lord. And there is paper person also issued, my lord, and it is there, my lord, but he not joined, my lord. Thereafter, my lord, he was dismissed from service, my lord. In my affidavit, this
You have filed
yes, my lord. This page 79, my lord. This
the pleadings are complete. We'll proceed for final hearing.
yes, ma'am.
Your name, please. Why don't you? There's something called a mic. Can you see that? Yes. Ms. R. Khatun, Learned Counsel, is appeared for the petitioner. Mr. S.K. Medin and CJC is present on behalf of the respondent. It is submitted at the bar that this matter is ready as regards pleadings. Since the challenge in this writ petition is pertaining to the order of dismissal from service, the matter will require deeper examination. As such, the writ petition is admitted to formal hearing. Since the parties are represented, no further notice is required inside. Register release this case for final hearing as a fixed item in the first week of February 2024.
Item
27.
My lord, the petitioner is a scheduled caste, my lord, but he applied as scheduled caste, but his case was not considered scheduled caste under unreserved category. His appointment was made, but. And now subsequently, my lord, the basis that allegation was that scheduled caste certificate was not issued by the SDO. But All India has filed an affidavit. Last time, my lord, the director, the government should file an affidavit.
Because we have cancelled the appointment of provisional appointment of the petitioner on the basis of the report submitted by the government. So government's affidavit is essential. We have already filed it.
Lordship, the instruction is not received, Lordship. Kindly accommodate 2 weeks time, Lordship. I will bring the instruction and file the affidavit, Lordship.
Fixed time will be granted, because I have been terminated. That is why.
The Mr. G.N. Saivula, Learned Senior Counsel appearing for the petitioner submits that the appointment of the writ petitioner who had applied as a scheduled caste candidate has been cancelled subsequently. on the ground,
Appointed as unreserved category, my lord.
was the appointment of the petitioner in the post of
Assistant technician.
assistant technician was cancelled
Assistant technician tenor.
on the ground that he had submitted a false SC certificate, although the petitioner was appointed as an unreserved category candidate. Therefore, the matter calls for expeditious disposal. Mr. K. Kalita Leonard, SC Oil India Limited, appearing for the respond numbers
5 to 7, Lordship.
5 to 7, submits that affidavit has been filed on behalf of the department. However, Mr. J. K. Goswami, Leonard, Additional Senior Government Advocate Assam, appearing on behalf of respond numbers
2 and 3.
2 and 3, prays for 3 weeks further time as final opportunity to obtain instruction and file affidavit. In view of the prayer made by Mr. Goswami, the registry to list this writ petition again as a fixed item on 4th of January 2024. Affidavit on behalf of the government be positively filed on or before 3rd January 2024. The matter will be taken up for disposal at the stage of admission hearing.
Item 28.
My lord, the petitioner case has been recommended by the my lord DLC. Lordship will find at page my lord 36.
See, ultimately, SLC has rejected on the ground of this 3 years issue, Lordship, and that part is already been pending before Lordship in the form of writ appeal, Lordship, before the division bench.
So, but you have not asked for any stay order before the division bench.
No, Lordship, in the due course, Lordship, it will come up, Lordship.
So, all right, then we'll have to allow these cases. You
And
are
there are-
pursuing your matters diligently. The notification is gone. Unless it is set aside by the division bench, that is the law.
Lordship.
You have not prayed for an interim.
Until there is a stay order, Lordship.
You have not even prayed for it. That means you want the court to pass orders remanding the matter. We'll observe it here. That the government is not interested in
Lordship.
interim. Then why have you not asked for a stay order?
In fact, Lordship, that is not the only that what I have provided, Lordship. There are many other Lordship similar matters which will Lordship asked to be.
All right, we'll fix it in first week of January and allow your petition. In the meantime, if they don't get a stay order. Yes. Mr. M.U. Mandal, Learned Counsel for the writ petitioner. Also heard Mr. C.K. Burwal, Learned GA Assam, appearing for the respondent. He prays for posting this matter again in the first week of January 2024, so as to enable him to obtain instruction as to whether any interim order has been passed by the division bench in the appeal preferred against the judgment and order dated judgment and order dated.
Yeah.
What is the date of the judgment of the learned single judge? Passed in the writ appeal pending on the question of law involved in this writ petition. Prayer allowed, list accordingly.
Item 30.
The respondents have filed an affidavit in opposition. We would like to file a reply to this. In this matter, we have challenged the disciplinary proceedings, which was initiated 4 years after the
You want to file
reply.
return? How much time you want?
Lordship, 1 week.
1 week we can't. Now, no matter will be listed again in December, unless there is earth-shattering urgency. So, Mr. B.P. Vora submits that 2 weeks. Learned Counsel for the petitioner submits that a copy of the counter affidavit filed by the respondents has been received by him, and therefore 2 weeks time be granted to obtain instruction and file rejoinder.
S. Chakraborty.
S. Chakraborty, Learned Counsel is present on behalf of the respondents. On the request of Mr. Bora, this matter stands adjourned for 3 weeks, so as to enable him to file.
Item 31.
May it please your lordship. Lordship, the matter pertains to my lord compassionate appointment. On the last date, my lord, direction was issued to take instruction from the respondent side. my lord.
So instruction here in this case is not received, lordship. Some time is required. Lordship.
My lord, my father was my lord died, my lord, and at that time, my lord, I was only 3 years old. Thereafter, immediately on attaining my lord majority, I applied for compassionate appointment. Then my
It
lord,
can't be given, you know it.
my lord,
These reliefs can't be
He
granted.
was 3 years old when the father died.
but my lord,
No, are you asking this court to pass or judgments against the settled previous decisions, precedents in this matter?
my
Or
lord,
you are not aware of the precedents?
my lord, I have a judgment, my lord, of this honorable court, my lord.
What does it say? These are sheer wastage of court's time. They will not listen. It will be dismissed. Where are the judgments which says it can't be done? You are also not prepared.
Here it was.
Date of,
2006 9 SCC 195, my lord, I think. The para 13, 14 and 18 I am relying.
No, this requirement of submitting the application within 1 year.
Yes.
This was introduced by which notification?
My lord, it came fall out of order of this court, Zivanasa versus State of Assam.
No, but what is the date of the OM?
OM is 2009.
And when did the father of the, he died in 1994.
1994, my lord.
That's the end of the.
And I applied in 8/10/2019, my lord. And my case was, my proposal was DLC recommended, my lord. And forwarded, my lord. that
DLC
will-
recommends everyone. They will just recommend and let it go. Let the courts and SLCs deal with it.
SLC
We'll
has
have to
not
call some
decided.
DLC officials and explain what criteria they are following. We'll do it very soon.
Till date, my lord, SLC has not
Uh,
decided, my.
Mr. M. Dattal and counsel is present on behalf of the petitioner. Mr. J.K. Goswami and additional senior government advocate Assam prays for and is granted 3 weeks further time to obtain instruction as per the order dated 20/2/2023 passed by the school. Mr. Ardhar Leonard SCPWD is present on behalf of the department. You take it back, you need it later. Yes,
Supreme Court is very clear, my lord, has passed an already order in state of Manipur versus Rajuddin, Muhammad Rajuddin.
Get the judgments.
My lord.
Ah,
My lord,
get
I'm
the
just,
judgments. Come prepared when the
My-
matter is called.
Obliged.
The petitioners had participated in the selection process, my lord. And they are challenging one of the clauses of the advertisement, which is against the principles laid down by the Honorable Supreme Court in Jitendra Singh regarding reservation, how the reservation is to be applied. My lord, on the last occasion, they were required to take some instructions on the vacancies available. And notice was issued. Now, they have only filed an affidavit answering the vacancy part. The rest of the petition has not been answered by their affidavit in opposition. If they want to go ahead with their affidavit in opposition, well, the matter is ready for either hearing or disposal.
Lordship, we have not replied to other paragraphs. We have only replied to that there is no vacancy because that is specific query of this honorable court, Lordship.
You have to file a detailed affidavit.
Lordship.
Then let them file it.
They had the opportunity, when they took the chance of
That's
only
right.
replying to one thing.
Sometimes opportunities are not availed. What to do? Mr. R. Majumdar, learned counsel for the petitioner is present. Ms. B. Sharma, learned CGC, has referred to the preliminary affidavit filed by the respondents to submit that filed by the respondents in terms of the order dated 31/7/2023 passed by this court to submit that there are no vacancies available. The learned CGC, however, prays for 6 weeks further time to file a detailed affidavit responding to the other allegations made in the writ petition. Prayer allowed, let the matter be listed.
Where this vacancy position was asked with regard to the interim prayers we had made for keeping the vacancies available. Now, perhaps, my lord, if lordship would observe that in case we succeed, vacancies in the CAPS be maintained, not from this advertisement, but yesterday I had shown the judgment of Gaurav Pradhan, where supernumerary posts were also required.
That will pass an order.
That interim-
There's no need to write anything now.
Published.
May I please, your lordship, here the petitioner, his promotion has been recommended by the DPC, but due to at that time, my lord, due to the pendency of the writ petition, my lord, his recommendation has been kept in the chill cover, my lord. Now there is no any cases, no litigation is pending, only writ petition was, the reason was that, my lord, one writ petition was pending before your lordship, but that writ petition has already been over, my lord. Kindly turn to page 21 annex 3, my lord. That is that the writ petition is then dismissed for non-prosecution, and only because of that reason, my lord, at that time, my lord, when the DPC was held, my lord, this case was pending before your lordship, and now there is no case, my lord. The DPC recommendation, lordship will find it page 25, my lord, in the bottom, further the selection board at page 25, my lord, in the bottom.
1 minute. When is the client retiring?
Return. Most probably 26, lordship, I am not confirmed.
Yes.
Instruction is still awaited. Only 4 weeks may be granted, lordship.
No, but you have to file your affidavit, you are not doing it.
Lordship, we have communicated and they are sending it. Lordship may grant us just 2 or 3 weeks time, Lordship. We'll be filing it.
All right, we'll grant you time, but we'll also make it clear that if
Yes.
no affidavit is filed, then we'll proceed to discuss the
ma'am.
matter. Mr. D. Borwal, counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved due to non-consideration of his case for promotion to the next higher level. Mr. B. Chaudhary, learned standing counsel.
Agriculture.
Agriculture Department, Assam, appearing for the official respondents, has sought 4 weeks further time as last opportunity to obtain instruction and file affidavit. Taking note of the prayer made by Mr. Chaudhary, registry is directed to list this matter again on 23rd of January 2024 as a fixed item for admission. The affidavit on behalf of the department be positively brought on record on or before 19th of January 2024 by serving advance copy upon the petitioner's counsel. It is made clear that if no affidavit is filed on or before the date fixed by the court, this writ petition shall be taken up for disposal on the basis of materials already available on record.
Oblige your lordship. Hi.
May I please, your lordship? The petitioner before your lordship applied for my lord constable in my lord CRPF, my lord, and after passing the my lord written test and my lord physical examination test, my lord, he my lord appeared for my lord detailed medical test, my lord, and in detailed medical test, my lord, his my lord my lord observed that my lord he is suffering from my lord some hypertension and little finger deformity, my lord. Thereafter, my lord review when medical board upheld the same, my lord. Thereafter, my lord, independently, I appeared in the my lord Fakhruddin Ali Ahmed Medical College Hospital, Barpeta, my lord. Everything was my lord tested, my lord. Everything found normal, my lord. So, my lord, that is why, my lord, I have come before this lordship, my lord. In a similar national case, my lord, our High Court, my lord, dispose of the same, my lord. And I have.
Lordship,
the
my
order.
senior is in legs, Lordship, after some time.
Who is the senior?
Mrs. A. Gayan, Lordship.
Let her come.
My lord.
Item 35.
Wait, please, your lordship. Lordship, instruction is still awaited, 4 weeks time may be granted, lordship, in this case.
4 weeks maximum, my lord, 2 weeks time maybe we can.
Mr. D. Bora, Learned Counsel is present for the petitioner. Ms. G. Bora,
Lordship,
Learned Standing Counsel, Agriculture Department, Assam, submits that instructions are still awaited and therefore 4 weeks further time be granted to obtain instruction and file affidavit. Prayer allowed. Let this petition be listed again in the 3rd week of January 2024. In the meantime, the respondents to file affidavit, being the stand on them.
So, that was recorded on the last occasion, that, lack of lavatory facility in one of the foreigners tribunal.
In that, my lord, I have received the instructions. My instruction says that already the estimate has been submitted by the PWD. And they have submitted the estimate for 8,30,000. Now that estimate will be placed before the Departmental Finance Committee for approval. Immediately after the approval, work will be started, my lord. That I have placed before your lordship.
No, this is another issue I just placed before your lordship. This is with regard to, my lord, the assistant government pleader in 7, 8, 9 courts. So interdepartmental communications are going on since July this year, but they are yet to be appointed, because of which the functioning of the tribunal, it got hampered, because without.
What kind of work the tribunals are doing? Are they giving opinions? Requisitive numbers?
But the monthly data regularly they are coming, my lord. In fact, they are functioning, my lord. Cases are, the references are there, my lord. Cases are there.
They are disposing of references. my
Yes.
lord. That is also my instruction, my lord. Listings of.
You give us compilation of some data in next 2-3 months. Give us some data. What kind of work the tribunals have
They are
done?
doing. Got it.
How many cases have been disposed of?
No. But I'll-
And what happens to the, supposing someone is declared to be a foreigner
Lordship.
and after the other remedies are exhausted, what is happening to them?
But now the Matia detention camp is there. Ultimately, after declaration, my lord, they have to, they will be there till the deportation, my lord.
Till
Until-
deportation.
Till deportation.
Any deportation has happened?
Yes, yes, my lord.
How many?
My lord, in one of the WP criminal petition is pending, a series is pending, my lord. There I got the instructions. I got the details of about 42 persons, my lord. In there, the exact date I forgot. Is that?
And how many have been declared foreigners last 1 year?
That data I'll place before your lordship. In fact, for deportation, my lord, now the state government has to take up the matter with the union, the external affairs ministry. External affairs ministry, they used to take up the matter with the the ministry of the other country where they are to be deported. That process, my lord, ultimately the Union of India has a role.
Here, the predicament is they are declared foreigners here, but the other country has to accept them. And it's
No, that's
only
right,
a few
but,
cases where the addresses are matching where they have been deported, lordship.
And in the others where it is not matching?
Lordship, they are in detention, lordship.
30, 40.
That is very small number, lordship.
So lavatory is being constructed.
It is, my lord, yes, my lord. Now it is at the
No,
stage
it is
of.
not constructed. They have processed it.
It is at the stage of placing the estimate before the Departmental Finance Committee for approval. Once, my lord, it will be approved, my lord, and after the approval, the renovation and repairing work will be undertaken, my lord.
So that is with regard to one foreigners tribunal, that is in Kachar.
No, my lord, there an application has been filed by the FT member.
This
my lord.
particular member.
This
my lord.
particular member.
Because
The FT member of that particular Silchar, FT, my lord, Foreigners Tribunal, he has filed an application that there is no facility. On that basis of his application, my lord, it was taken up.
And the other issue he has raised is regarding engagement of assistant.
Government leader.
But
my lord.
in fact,
leader.
Lord, this is,
Yes,
this
almost
matter is
not-
relating to infrastructure bench, my lord. And as regard appointment or engagement of leader, some process is going on. I have to take the instruction, Lord, because those documents I have,
Almost in
he has given me today.
tribunals, almost in 8 tribunals, my lord, this assistant government leader is lacking, my lord. And
I
interdepartmental.
heard Mr.
communication-
Esketas Nanas, standing counsel GHC appearing as amicus curiae in this case. Also heard Mr. D. Nath Nanas, senior government advocate Assam, representing the State Home Department, Mr. R.K.D. Chaudhary Leonard, DSG appearing for the Union of India. Mr. S. Dhar Leonard, registered judicial, is personally present before this court. Referring to the two issues raised during the course of hearing today, Mr. Nath has submitted that insofar as the construction of lavatory.
Repairing and renovation.
Repairing and renovation of lavatory facility in the first Foreigners Tribunal Silchar Kachar. An estimate has been prepared and submitted before the Finance Department.
The Home Department.
Home Department
Okay.
for necessary approval, and therefore the matter is under process. Responding to the plea raised by Mr. Das Leonard amicus curiae regarding non-availability of assistant government pleader in as many as 8 to 9 FTs in Assam today, Mr. Nath has submitted that proper steps for engaging assistant government pleader in all the tribunals is underway, and therefore updated instructions will be obtained by him and presented before this court on the next date fixed. It appears from the submission of learned counsel for both the sides that there is no other urgent issue arising for consideration of this court in this consideration of this monitoring bench in this matter. In view of the above and considering the fact that the winter vacations are approaching, registry is directed to list this matter again on 19th of January 2024. Fixed item.
Thank you.
May it please your lordship. Lordship, I am appearing on behalf of B Pathak. B Pathak is out of station, lordship. I'm praying for an adjournment.
Item 37 to
39. 37 to 39.
37 to 39, the learned counsel for the writ petitioner stroke contempt, learned counsel for the petitioner in these proceedings have sought adjournment in the matter on the ground that the arguing counsel, Mr. B. Pathak, is out of station. Ms. R. Devi Leonard CGC is present and does not have any objection in the hearing. In view of the above, let these matters be listed again in the second week of January 2024.
Lordship, one more prayer, one contempt case is pending similar. That
Along
may be
with-
also tagged
Along with
together.
contempt case number
623 of 2023.
623 of 2023, which is stated to be connected with these matters.
Deeply obliged.
My lord, the official reflects that services complaint in a contempt case. Possibly Mr. Dean is appearing.
Well, the speaking order has been passed. I have given a copy, Malad. Yes. No, it is marked to the petitioners also. I'll give a copy, Malad.
Is the order speaking loudly or very silently? The speaking order. Prayer has been rejected.
Yes, Malad.
This has become a pattern.
No, Malad, it's a speaking, they have considered all the grounds, Malad.
Speaking, order speaking makes somebody cry. That's not the right idea, I suppose.
Well, they have said that considering all the above facts and circumstances, Mines and Mineral Department, Government of Assam finds no reasonable ground to consider the application dated 17 to 2021 submitted by the writ petitioners. And the petition is disposed of accordingly.
Then we
They
have to
have-
close it. You
We
challenge
have to
it.
challenge this. The master
Understood.
won't work our mind. They claim.
No,
we-
that's the problem. In
As per
these
the-
matters, you have to get a determination from the court. This
Right.
speaking order, who cares for master law worker?
That is.
As per the finance department,
Nobody
sir.
wants to pay them salary or even whatever is the minimum wage. Because there could be reasons, there is a huge financial involvement. These are people who can be made to struggle probably, that's what. But we'll deal with these matters. You file a writ petition, argue, make out a case, we'll pass a mandamus if necessary. No difficulties. Speaking orders will not help in these matters.
No.
As per the finance department, OM, my lord, they are not, and pension cannot be given to them. That is the order, my lord.
Why? Because they have not spent the minimum years of service.
That the finance department, OM is very restrictive, my lord. They have not, they included them.
No, Mr. Nath, this is what I have been telling in the morning also.
Lordship.
We are not concerned with your OM. We will look at what is the constitutional scheme.
Lordship.
We will see whether these actions are in consonance with Article 14 and 16. If not, we'll do our duty.
In a proper.
So that is why
Lordship,
I'm
lordship.
asking him to file a
Correct.
proper writ petition.
Correct, my lord, correct.
OMs, the finance department has their own compulsions. We're not saying they don't have. They are juggling with issues that we understand. But
True.
we'll have to go by the mandate of the constitution.
Correct.
If they can make out a case, we'll interfere, otherwise we'll not.
Lordship.
There's no point subjecting these masteral workers to speaking orders and running from pillar to post. There's no point. That's all I'm saying.
Correct.
There may be justifications for the government to take a stand.
True, my lord, true.
The governments will have to run their business with the limited resources. We're conscious about it. But ultimately, it is the constitution that matters. We'll have to go by that.
Yes.
Mr. B of Learned Counsel for the petitioner also, or Mr. D Nath, Learned Counsel appearing to the respondents, who has produced a copy of the speaking order dated 30th of October 2023 to submit that in terms of the direction issued by this court, the case of the petitioners had been considered and rejected by the said order. If that be so, nothing further survives for adjudication in this contempt case. Therefore, by granting liberty to the petitioner to assail the order dated 30/10/2023, if so advised, the contempt case stands closed. Okay.
But please, Mr. Lordship. Yes, a matter pertaining to non-payment of retirement benefit, Your Lordship.
Non-payment of
Retirement benefit.
retirement benefit.
Leave encasement and gratuity.
Why you are appearing for whom?
My lord, I am appearing for the respondent, my lord. According to the last order, my lord, we were directed to file the additional affidavit, my lord. And there has been only one problem is there, my lord, that the respondent has now transferred. That is also reflected in our affidavit, my lord.
No, when did the petitioner retire?
My lordship, the date of retirement is 31/2021.
And retired as what? Petitioner retired as what?
My lordship, as senior office assistant, my lordship.
All right. And why pension has not been settled? What is the reason why the pension has not been settled?
My lord, for that, my lord, I have filed, there were certain communications were done, my lord.
No, do you understand? It's a contempt of court proceedings.
I totally understand.
Absolutely no chance of. Why the pension has not been paid? Tell us that. Give the answer.
My lord, for that, my lord, I will need some time because.
We'll give you time. 10:20, or else there will be direction of personal appearance. In next 10 minutes, you tell us. You think contempt matters are a matter
I
of joke?
understand, my lord. But there is, my lord, what has happened, my
In
lord?
10 minutes, you tell us why the person's pension has not been paid.
My lord, if my lord may go of the order, last order, my lord, of this honorable court, my lord, 28/8 of.
We are only, what is your name?
A day, my lord.
A day. You are appearing for the sole respondent.
Yes, my lord.
We are only asking you, why haven't you paid the pension of this person despite the order of the court?
My lord, this.
You are telling us what is there in
No,
this
no, my lord,
page.
this is-
Why his pension has not been
This
paid?
has been recognized as a sick industry, my lord. That was the reason. And there were several communication we have made on our part to the finance department. And thereafter, my lord, this was the affidavit which I have filed, the additional affidavit. So that was.
No, but Sikh industry, if he is otherwise entitled to pension, you have to pay you have not made finance a party.
My lordship, the direction was us to the.
These are the
con-
problems you
Yes,
create.
my
No?
lordship.
My lord, there are similar.
Any matter involving financial,
Yes, my lordship.
you have
One
to
con-
make the finance a party.
No,
How
one
many times this has to be said?
My lordship, direction was.
There are
to-
similar matters, my lord, that can be tagged along, my lord.
No, nothing. If the finance was a party, then we could have.
In some matters,
You are
there
not
finance is a party,
facilitating.
My lordship, one contempt matter, contempt case number 145 of 2022. In that matter, finance has been made party. And
No,
these
but we
similarly
are
situated,
concerned
my
with this
lordship.
matter. Why you have not made finance a party yet?
My lordship,
You demand compliance from
my
the
difficulty
finance
is the
and then
direction
come.
was to the sole respondent.
No,
That's why
no,
in the order it
direction
has
was
been-
there, but you want monetary benefit, is it not?
Yes, my lordship.
Then the finance is always a party. Finance is holding the key to every penny of the state. Without the finance presence, nothing can be implemented. Even if there is a court order, it cannot be implemented.
My lordship.
If you are the custodian of the money, without hearing you, can somebody direct someone to pay? It can't be done. You must use your common sense. No? What is your name?
P.S. Raja, my lordship.
Huh?
P.S. Raja.
The Mr. P.S. Raja, Learned Counsel for the petitioner seeks leave of this court, demand compliance of the order of this court from the concerned officials of finance department and thereafter file appropriate application for implement. The said prayer is granted in view of the stand taken by Mr.
A.D.
Learned Counsel for the sole respondent who submits that since the enterprise has been declared a Sikh unit, no Sikh industrial unit. Industrial unit.
It's a public sector.
Sikh public sector undertaking. There is no resources to pay the pension of the employees, including the petitioner. List the matter accordingly. You have to implement the finance. There has to be direction to provide finance, otherwise it is not going to work out. Yes. Yes. Who is appearing in this case?
My lord, in this matter, my lord, we have complied with the court's order, my lord. Issued a check, my lord, they have collected the check, my lord. But because of a new system, bank system, my lord, PPS, the check was returned, my lord. Yesterday, we have complied, my lord, and we have submitted the PPS, my lord. They will get the money within a day or two, my lord.
So, Chief, I have no objection, but check were already returned.
All right. This is item
42, my lord.
42.
42, my lord.
Mr. S. Burman, Learned Counsel is present for the petitioner. Mr.
S. Das, my lord.
S. Das, Learned Counsel appearing with respond number 2 submits that in compliance with the order of this court, a check, the amount has not only been sanctioned, but a check has also been handed over to the petitioner. However, due to some malfunctioning of the payment system,
yes,
the check was not honored. The aforesaid anomaly is being rectified by the department within the course of the next week. Mr. Datta therefore submits that the contempt case can be closed. You are appearing for?
Industries and Commerce Department.
Mr.
N. Kalita.
N. Kalita is present on behalf of the respond number
1.
1, 2.
1, 1.
1.
Surprisingly, people are appearing in the cases without knowing who they represent. They don't even, some of them don't even know what is their name. Is present. Taking note of this submission and assurance given by Mr. Datta that the payment will be received by the petitioner without further delay. This contempt case stands closed.
Highly obliged.
Note to this. May it please your lordship. This matter is with regard to the custody of a girl child. Note to this, sir. I have made a small note with regard to the date of
Where is the order, Mr. Bhuya?
yes, orders, my lord, will kindly.
Before my learned friend starts, madam, can I make one small submission?
My lord, in the petition, what has been alleged is violation of an court order passed by the family court, basically. Lordship knows under the scheme of the Contempt of Courts Act, when one alleges violation of subordinate court's order, then unless the subordinate courts refers a statement, my lord, High Court will not register a case. No, this is absolutely not in form, it's not maintainable. My lord, it's not in contempt of this honorable court, it's a contempt of family court's order. Number one, my lord, there is a provision for execution of the court's order under section 18 of the family court. Secondly, my lord, order has to be willful. It's not a willful order. Now, if a lordship would kindly have the Guwahati High Court rules, my lord, the rules framed under the Guwahati High Court Rule 9C, when a contempt can be registered by the High Court. Only when, my lord, the statement is forwarded by the, my lord, subordinate court. That is not the case here. And in any case, my lord, the child doesn't want to go. And the court is also considering the order in respect
Just a
of.
minute, where is the order? I wanted to
Yes,
see the
Yes. May I take your lordship, my lord?
Yes.
Yes, first order, my lord, 9/3/2021, my lord, page 85. Starts from page 85, my lord, is run to 86, my lord. Now, this has been the order. Here, the respondent filed a guardianship case. We have paid for custody of the child, and after hearing both the parties and after hearing my minor daughter also, my lord, and this order was passed that yes, at page 86, last paragraph, my lord. In view of the I find it be justified to allow the prayer of the respondent, hence court directs the petitioner to hand over the minor child so and so to her father, respondent, on every Saturday evening at 4 p.m. Will take his daughter to his house, and he will again bring the minor back to her grandmother's petitioner house on the evening of every Sunday at 6 p.m. During the afternoon of Saturday and on Sunday, the respondent shall take the minor to all the extracurricular classes if she has any such classes during those period until further orders. Now, this is the first order of the family court. Now, the second order, my lord, will kindly come at page 103 and 131. 103, it starts, my lord. 130.
Yes.
Page 130, my lord, D, my lord, will kindly see. The respondent number 5 to 11, including the respondent number 6, are reminded to their solemn obligations to abide by the said order dated 9/3/2021 in Mizi case number to give Z to the temporary custody of A from 4 p.m. of Saturday evening to bring her to his house and to return to Z in the custody of the respondent number 6 at her house on the evening of Sunday. Same thing, my lord. And with regard to, my lord, this is, yes, this is with regard to the High Court's order, my lord. And next order is 4/7/2022, my lord. That is page 153. Yes. Yes.
What is the order in page 31? This order is passed. Where does it begin?
It begins from, my lord, 103. It begins from 103, my lord, and the operative portion, my lord, 131. That was a habeas corpus because in non-compliance of this order, my lord, the family court's order, my lord, the girl was not been given in custody. So accordingly, we filed a habeas corpus. In that, interim directions was given, my lord. And thereafter, after hearing them, this is the final order. Where
So
it is,
there is a dispute regarding custody of a child.
yes, I'm the biological father, my lord. This is very important. On 9/3/2011, I got married, my lord. And the daughter been born.
Married to whom? Married to whom?
Married to the, my lord, my deceased wife, my lord, who expired.
Okay.
23/8/2012, this minor girl was born, my lord. Unfortunately, my lord, she has had high pressure, my lord. On 3/9/2019, my lord, while he was working, he's a software engineer in a American software company, namely Oracle. Now, while working, he heard distress sound. He rushed back. He became panicky. He tried to survive. He called his neighbors, and all of them arranged ambulance took the hospital, but she expired. Police was informed, UD case registered, and viscera and everything was taken. Then family members were also being informed. They flew from Guwahati. The deceased was body along with the minor, and the family members came to Guwahati. Deceased body was taken to the respondent's house, then to my house. Last ritual rite has been conducted at my house. They didn't appear, my lord. I myself took my minor daughter so that she spent quality time of the in-laws also on 29, my lord. We said this, that I have made the return ticket on 29/9. So on 28/9, when I went back to take my daughter back, I've been assaulted, my lord. My specs been broken. I lost an affair, my lord. They lost counter affair with regard to this. I didn't get any relief. I went to my lord CWC. CWC directed, bring the biological father handover. They didn't. They hospitalized the girl. In the meantime, they filed a guardianship case. We come to the court of law. We abide by the law. We waited patiently, my lord. Girl was not being given in custody, my lord. Thereafter, my lord, after the family court's order, my lord, repeated FIR has been lodged against me, my lord. What, my lord? In puja and everything, my lord, we give pajals. We take everyone in Saraswati puja and all this. They lost an affair there, we are poisoning the girl. FIR has been lost. I got anticipatory bail here, interim. Thereafter, final order I have annexed. That nothing has been in the case diary, my lord. And this is FIR over FIR has been going on. And what happened in that particular UD case, my lord? Final report was submitted. They were given notice. They received the notice. They went back, my lord. Went and get Narazgi petition. And they made statement before that. And that's been pending in that particular Bangalore court, my lord. Viscera test, everything has been done. Or everything has been there. It's been heart attack, my lord. And they are protecting me in front of the girl to be the murderer, my lord. And poisoning the girl, my lord. The mind. I am open to anything, my lord. The welfare of the child is the paramount consideration. It's not a commodity, my lord. The best education institution, I am ready to put her there also.
All right, now there is an order from the family court.
Family court, my lord. Then habeas corpus petition, my lord. In the High Court also it has been stated to abide by that. And when we went back after the High Court, my lord, that was the time of Bihu festival. So we prayed a prayer for 4 days, my lord, this one. Court allowed it to be the father. They didn't. They didn't allow it. And they, my lord, against that order, they filed civil revision, my lord. They state the order. The prayer is over, that matter become infectious. Again, we filed that the girl is not been coming to me. They have been stopping it.
How old is the girl now? How old
now
is
she's been born in 2012, my lord. 11 years, my lord. They have poisoned the mind, my lord, against their own father, my lord. She has been studying in DPS Bangalore in the best institution. Excellent career, my lord. She's very sharp girl.
the father stays in India or abroad?
India, my lord. And for that fighting of the girl, my lord, he took permission. Either will fight for the job or I'll give me work from home. He's working from here only, my lord. From Guwahati, my lord. 210 nail, my lord. No justice, my lord, till now. Natural biological father, my lord. That's my case.
My lord, the lordship will not adjudicate lordship is adjudicating a contempt petition, my lord. My submission is this contempt petition is not maintainable. If your lordship wants me, I can address on merit also. It's a contempt case.
Mr. Chaudhary, you
No,
address on
how
whatever-
how can your lordships entertain a contempt petition for violation of a subordinate court's order when the statement has not been prepared by the learned court below and forwarded to the High Court? That is the basic requirement. Lordship will kindly read Rule 9C of the Guwahati High Court rules. Framed by.
We'll go into that.
Yes.
But if the petitioner is the biological father, how can
He could be the biological father. We are not. The child is not prepared to go. In fact, it's not that he has not been permitted to meet. From time to time, he comes, he meets, my lord. In between for 19 days in child home also, the child was kept. My lord, in fact, the trial court is on the, now has issued an order on 26/7/23 for reconsidering the original order. Kindly have a look at this order, my lord. This order should be brought to your lordship's notice. Kindly see, my lord. Parties to the case are present. The instant proceeding is fixed for cross-examination of PWs, but parties have come to an agreement to hesitate the matter regarding right of visitation and to have access to the child by respondent, particularly arising out of order dated 9/3/21, which my learned friend read. It is submitted by the petitioner that the order so passed by this court cannot be meticulously complied because child in question is in the state of father phobia when he is going to approach the father. Accordingly, the petitioner so desired that order that it is not compatible and not commensurate with the word of its compliance and prays for before the court to revisit the order, so to say, review and as such file the application in the earlier date. Before delving into the scope of revisiting the order, particularly in the family court, there are some gray area which needs to be considered, but considering sensitivities, the sensitiveness of the matter, let the matter may be considered after fruitless hearing. Copy may be given for filing. On last occasion, time was, no? The matter was adjourned. So, my lord, the court itself is in the process of reconsidering the order. And I can also bring to your lordship notice some of the statements from where it will appear why the child is not prepared to go. If your lordship would kindly take our affidavit, my lord, page 233. Order.
Page 230.
Child Welfare Committee's order, page 233, my lord. On, as your lordship's got it, 233. On this day, that is 3rd October 2019, as per verbal telephonic conversation with Mrs. Nilima Goswami, a CWC member, Kamrup Metro, the 7-year-old girl named Avantika Mohanto will be handed over to the maternal grandfather, Srimati Joymoti Patwari, for overnight. The child will be brought to CWC Kamrup for reviewing the father's decision tomorrow on 4th October at 11 a.m. On the day 4th October 2019, the child's father and grandmother paternal, along with grandmother maternal, and one other member of the family managed. The above decision had to be taken due to the child's adamant and hardcore decision of not wanting to go with her biological father in any case. The child cried and only wanted to be with the maternal family for the night. She promised to go with her biological father tomorrow at 10 a.m. and for the day she wanted to stay again with the maternal family tomorrow night. So these are the situation. There's one more order, my lord. Please come to page 235.
This you are reading is an order passed by?
This is also, my lord, CWC. Please come to page 235, my lord. The girl's statement. I took the statement of Avantika as where she lived, where she studied, etc. I asked about her mother. She said she was very good. And when asked about father, she said she does not want to go with her father because she could not see again what happened with her mother. She did not say anything when I asked what happened to her mother. Last, she stated clearly that she won't go with her father. After her statement, it seems to believe that she would not recuse yet and she would remain with her family. So we did not recuse her today and let her stay with the relatives. But we told her relatives that they must come to so-and-so for so-and-so statement. So these are the situation when, my lord, even the child welfare board also, my lord, they had to, change the decision from time to time. Now, where is the question of contempt? Section 2B of the Contempt of Courts Act says contempt has to be willful and deliberate. My lord, we are saying, please, all that has been ordered is every Saturday, my lord, at 4 o'clock, she will go with her father and 4 o'clock on Sunday, she will come back. That is the order. We are prepared. If she is not prepared to go, what to do, my lord? Who is the question of poisoning? Who is poisoning whom? Who has killed my mother, the child's mother? The cases are going on. My lord, there are serious statements, my lord. Now, question is, lordship is adjudicating a contempt petition. Now, please have contempt of act for a moment, my lord. My lord will have section 2B. Civil contempt means willful disobedience of any judgment, decree, etc., etc. So there has to be a willful and deliberate violation. Which is that, my lord? Which is that willful violation? Who has willfully violated whose order? Then my lord will kindly come to section 13, my lord.
Yes.
This is the premise on which, my lord, the contempt law proceeds. Notwithstanding anything contained in any law for the timing in force, no court shall impose a sentence under this act for contempt of court unless it is satisfied that contempt is of such a nature that it substantially interferes or tends substantially to interfere with the due course of justice. Is it a case of this nature, my lord, that my learned friend is asking your lordships to invoke the powers? When the child is not prepared to go, when the child welfare boards are finding it difficult to handle, we never said we want to, in fact, my lord, in terms of the lower court's order, we have permitted. They have gone also on a few occasions. And in the birthday, my lord, she was taken, that we are not objecting. All that is required is every Saturday evening, she will spend some time, and then Sunday at 4 o'clock again she will come back. But when she is not prepared to go, having seen the plight, my lord, now the court itself which passed the order is in the process of.
Have you stated that in the affidavit?
Yes.
Where is the statement?
Yes. And there are certain additional developments also, my lord, which I was thinking of bringing it on record. It will be. Now, please come to page 180, my lord, para 10. That with regard to the state, has your lordship got it, my lord, page 180.
Yes.
That with regard to the statement made in paragraph 12 of the contempt petition, petitioner is contradicting his own statement here. If the respondents were not allowing him to visit his daughter, then how come he was able to take his daughter for visitation? On 30/10/19 at around 4:44 so and so, Partha Mohanto visited Joymoti Patwari's house at Hengrabadi in a drunken state and tried to forcefully take Avantika along with him. This led to a chaotic situation in the house, with Avantika offering stiff resistance to Partha Mohanto. Partha Mohanto tried to grab Avantika by her arm, drag her out of the house. In swiftly intervened, and a minor scuffle broke between us. Partha Mohanto started hurling abuses at Joymoti Patwari and her family, and he threatened to kill Joymoti Patwari and Avantika. The said incident was reported to Dispur police station while FIR dated so and so, and the same was registered under so and so provision. The said incident left a deep scar in the mind of the Avantika, and she became furthermore abhorred to the idea of meeting her father. It is to be mentioned that Partha Mohanto approached district court with false allegation of detaining Avantika illegally by respondent and lodged the case by memo dated so and so. Upon inquiry, district court also learned that the case is already going on family court for her custody, and it is not a matter of illegal detention. Thereafter, Partha Mohanto filed petition number under section 12 of the Act and is pending, seeking permission of the court to take Avantika every Friday of the week to keep her with till Sunday.
All right. Now, what has happened to this miss case, Mr. Bhuya?
Which
Miss
one?
case G number 161 of 2019.
Nothing, my lord. It's been pending out there. My lord, with all respect to a
Pending, it's
senior
pending.
colleague of mine, my lord. He has taken with this court with certain documents. May I take this honorable court with regard to page 86 of my writ petition? It's my petition itself, my lord, contempt petition. While passing the order dated 9/3/2021, my lord, the court has taken the view of the girl also, girl child, and it's been reflected in page 6. Second para, my lord. It is an admitted fact that the respondent is the natural guardian of the minor, being her father. Again, on a brief interview held by this court with the minor girl on 11/2/2021, she revealed that she loves both her father as well as grandfather. That's been the observations. Now, my lord, thereafter, after this, they complied with it for a few months. Now, COVID broke out, my lord, and within that period, some areas were restricted, my lord, that containment zone. Then the girl was with me when containment zone was being declared. So I was supposed to.
That's all right. Mr. Bhuya, you please respond to this part
Yes.
of the allegation.
Yes.
Mr. Chaudhary is saying that they have no objection if the order is implemented.
Yes.
But it is a girl who is herself reluctant to go with her father.
That is because of the fact that all along it's been poisoned against the father.
No, but how can the court decide this aspect of the matter in a contempt case?
No, my lord, in that view of the matter, my lord, this court has all the powers, my lord. Let there be a conciliation proceeding, my lord. This court handles so many cases, my lord, can understand what is going on
Are
inside.
you, 1 minute, are you
Conciliation proceeding, my lord, no issues at all, from my side. The father will come.
conciliation
They will come.
between whom?
My lord, the child, the court may interact with the child, whether it's been influenced or not. She become arrogant nowadays. She is been behaving totally different, my lord.
Mr. Bhuya, please respond to this question
Yes.
specifically.
Yes.
We are not supposed to go emotionally in these matters. Though
My lord,
the facts can
this
be.
is inhuman, my lord. Very inhuman, my lord.
The matter.
It is my
You see,
child.
Let's be very pinpointed on.
Yes, yes.
I am not even taking note of the technical argument. Of
Yes,
this.
sir.
Though I know he is substantially correct on that. You cannot directly file a contempt case for violation of a civil court order. That is the law. But I am
My
not
lord,
going.
Section 10 talks contrary to it. Section
We'll go
10
into
of the
that.
Contempt Act, my
We'll
lord.
go into that later.
Yes.
At the moment, the law is very clear that contempt of court proceeding can be drawn up only when there is a willful violation.
Yes.
So the allegations you are making is not a direct case of willful violation. You are saying these people, the opposite parties, have poisoned the mind of the child,
And my
as
lord,
a result of which she is not willing to go. That you are agreeing. But you are saying this is because they had poisoned her mind.
they have obstructed in every meeting the girl. What is this, my lord? I cannot meet my own child. I cannot go to the school to take what has been her performance.
So what is the way forward? The contempt is
Way
putting
forward
them
is
behind
very
jail
simple,
is
my lord.
definitely not a
I leave it to your lordships, but my only prayer is this at this stage, my lord, that he being a biological father, all along
why
with
don't
their-
you come up with some solutions?
That's what I am on, my lord. That the best way out is this. The person who have filed the guardianship case, the person, the father, the child, take the impression with regard to this and pass any order in this. Because this is never ending, my lord. This is a tug of war been going on with the child. And father is reluctant, my lord. But he loves his daughter anyway, my lord.
No, Mr. Bhuya, you are not appreciating. You see, you forget the emotional part.
My lord, conciliations can be, my lord, because these are the matters has to be
So conciliation between whom and by whom? That's what
by
I'm
this
asking.
court, my lord. I
Court doesn't get into conciliation.
my lord can appoint any conciliations. There are here, my lord. This my lord can give that and a report may be called for.
Who suggests someone?
Anyone, my lord. Anyone, a lady, my lord.
No, you have to come up with something concrete.
Concrete, my lord, will be Nikita. Is a conciliation is there.
No, not the name of the conciliator. What exactly are you suggesting?
They will suggest with regard to my lord and with regard to my lord, any psychiatrics also, my lord, in that conciliations. Take the view of this, my lord, how the girl has been affected in that manner. Because all along she's been brought up, no complaints, very excellent girl. All of a sudden, all large ritual right in my house. And thereafter, my lord, I voluntarily gave it that love and affection of the in-laws also. And when I went back, altogether changed. Why? And for that purpose, my lord,
You think about the queries.
for
made by-
appointing, my lord, one counselor, my lord, with an expert, my lord, say, my lord, Mithili Hazarika is one, my lord. And in that view of the matter, in view of their reports, my lord, court will take a call, my lord. Because this is sensitive matter, my lord.
My lord, I'll just one order of the court below of 8/4/22.
More copy to the Lord.
Yes, move to edit. My lord, kindly come to page number 2, my lord.
Yes.
I have interacted with the minor in my official chamber. Precaution was taken so that the minor girl remains free from influence. The minor girl told that she did not want to stay with her father. She's scared of her father because He used to scold her. He likes her grandmother, maternal aunt, who loves her like her mother. Whenever she visited her father's place, she remembered her mother. So these are the views which the child has expressed before the learned court below. My lord, in a contempt proceeding, with all respect, I'll submit, my lord. Lordship will not go into all these things. Lordship will decide whether it is a contempt or not, one. Secondly, my lord, when the family court is in session of matter regarding any, my lord, I mean, sort of compromise or what can be worked out, let family court make an attempt, my lord. In a contempt jurisdiction, why your lordships will go to all these things, my lord? In my humble submission, my lord, lordship will not do. Lordship will see whether there is a contempt or if he has. Or,
No, that's all right. From your client's standpoint, your
Yes.
submission is well taken.
Yes.
But are you also submitting that the court cannot go into anything?
No, I'm not saying. No, that I'm not saying, my lord. Only thing is what I'm saying is, my lord, no, since he is in contempt jurisdiction,
No, that's
therefore, lordship will appreciate my submission in that
No,
light.
that is appreciated,
Yes.
Mr. Chaudhary.
Only that much.
The court is only thinking what is
Welfare of the child.
what is a just way forward keeping the welfare of the child.
I think, my lord, the lordships can direct
contempt and
the
all
family
this.
court whether the matter can be referred to mediation center or something. That let
Mediation
family.
between whom? That's what I'm asking.
That's the whole difficulty.
Between whom? If the girl doesn't want to
That's
go,
the whole difficulty.
you can subject the minor to mediation.
So therefore, my lord.
That's why I was asking Mr. Bhuya, give me
Absolutely.
a concrete proposal.
Yes, absolutely.
Just by saying something here and there. it
My
may
lord,
not
the
be
girl,
possible.
the girl has seen.
May I pray for a short day, so
Yes.
I can think over, my lord.
You
and
think
that-
about it,
Yes,
say something which is
Yes.
legally permissible.
yes.
And which is, I will request both of you not to say things
No, no,
only
my
from your client.
Yes, yes, yes.
Let us have the child's welfare also.
Absolutely, that's the paramount, my lord. It's not a
If the
property,
child,
my lord.
if there are convincing and reliable, credible material to show that the child is reluctant to go with her father, then the matter will have to be treated that way. Forget the technical part of the contempt. It may or may not be there. If it was treated like that, we could have finished this matter 15 minutes back.
Absolutely.
But what is the way forward? And whatever concrete proposal you have, that must be in consonance with the provisions of law.
Absolutely.
So how much time do you want to examine
Let it
this?
come on 4th of December, my lord. Till then, my lord.
Fourth, not for the following week, my lord. Fourth, I have some. I'll be not there.
Acha, you will be out of
Yes,
station.
my lord. Fifth, that matter is coming out. If at all it takes place. Every time we go and come back, my.
All right, all right.
Could it be lordships can take it up on 18th, my lord, to be on the safe side?
18th, my lord.
18 December.
Yes, December.
Mr. A.K. Bhuya,
18
learned
December.
counsel has appeared for the petitioner, also heard Mr. K. Bhuya, and senior counsel is heard by Ms. R. Kakati, learned counsel appearing for the respondent. After hearing the submission of learned counsels for both the sides, this court had desired that a concrete proposal be submitted by both the parties to resolve the issue, keeping in mind the welfare of the child. On such ground, the matter is deferred till 18th of December 2022,
Mine.
so as to enable the parties to
Mine.
come up with a solution.
Declare.
Let us solve it.
Yes.
Let us
Instead
solve
of
it, my lord.
Our instruction.
putting it.
Very unfortunate, my lord, what is
That's
happening.
unfortunate, yes.
Item 44.
May I please? Lordship, in this case, Lordship, non-compliance of order dated Lordship, 26/9/22, Lordship, page 9, Lordship.
You are appearing.
Yes, your lordship. Lordship, I've received my instructions. Lordship may grant me some time. I'll file my
You are appearing
affidavit.
for whom?
For the sole respondent, only one person is made a party.
My lord, other similarly situated Lordship persons who are complied with the order, Lordship, fire the order, Lordship.
All right, she wants some time, we'll give her.
Lordship.
But
We received
Mr.
instructions.
E. Malakar, learned counsel for the petitioner, also had Miss N. Bordello, learned counsel appearing for the respondent. Sole respondent who praise warrant is granted. How much?
2 weeks.
2 weeks further time to obtain instruction.
No, your lordship, I've received the instructions and file my affidavit.
2 weeks time to file affidavit. Prayer allowed, list the matter accordingly.
And
So
the-
other orders have been complied with, that's what he's saying.
Yes,
Lordship,
regarding-
in other
regarding-
cases, Lordship, I have the.
Regarding the petition. Yes, your lordship, regarding the petition.
The other matter to be put in the family matter.
May it please your lordship. Your lordship, the order dated 9 June 2022 has been already complied. and hence we would like to withdraw the instant matter.
Your name, please?
DB Gohai.
Ms. D.B. Goyal and a counsel appearing for the petitioner submits that the order of this court has been complied with and therefore the contempt case be closed. Mr.
R.K. Musari.
Musari and Mr.
Respond-
S. Bora, learned counsel are present on behalf of the respondents. Taking note of the submission of petitioner's counsel, this contempt case is closed.
Highly honorable.
My lord, OP number 1 and 3, my lord, they filed their opposition, affidavit in opposition, my lord, but OP number 2, my lord, address is late, my lord. So, my lord, I may be allowed to take instruction.
My lord, the order has been complied with. What is there, my lord? If anybody files, the director has, this respondent number 1 has already filed. My lord will just see the last page of the contempt petition, my lord. That is the operative part, my lord. Last para 7, my lord.
Yes.
আপনি তার কারণে- হ্যাঁ।
So which order has been violated? 22/6/2022.
My lord.
Such a order has been complied with. Lordship. I appear for respondent number 2.
You have
I have
to-
subsequently been transferred, Lordship, but the officer who is in position, Lordship.
না না বিদ্যালয় কিছু পরীক্ষা বই পরিষদ এটু
On this.
So my lord, we have filed our affidavit in the last page, my lord. It is there. It may be noted that the vacant post of Anganwadi worker of Bamundi Nagar and such, where the writ petitioner has been working as Anganwadi worker, were also advertised and the writ petitioner had participated in the said selection
The
process.
order has been complied with, will close it.
My lord, one part not complied, my lord, because my lord, this impugn order, my lord, Honorable High Court, my lord, paragraph 6 of the
Which
order.
part has not been complied with?
My lord, paragraph 6, my lord, my lord, their demotion order, my lord, stay. So, my lord, by virtue of stay, my lord, this Anganwadi, my lord, worker entitled to, my lord, get the fixed pay of Anganwadi worker. But my lord, the respondent were paying, my lord, the fixed pay of Anganwadi helper. No, my lord, one order, my lord. I have not.
Order dated 2/2/2022 has also been stayed.
Yes, my lord.
Is it 2/2/22 or 2/2/21?
My lord, just now, my lord, I got a order dated 7/9/23.
Oh, this order shows that there is an order dated 2/2/2022, which is also stayed. But the order of the court mentions order dated 2/2/2021.
Yes.
My lord.
Which is correct.
My lord, order dated, my lord, this.
All right, on the prayer of learned counsel for both the sides, this matter stands adjourned for another 4 weeks so as to enable them to obtain instruction as to whether even the order dated 2/2/2021 as per direction of this court has been stayed. And if not, the reason thereof. List accordingly. Party nominee divorce. So and so for petitioner. Mr. N. Bhagavati for respondent number 3, Mr. R. Dhaw for-
1 and 2, my lord. But my lord, 1 has filed, that will suffix, my lord, because we have already complied. She has already
R. Dhaw submits that
participated in the
order of
exam.
The court has already been complied with. However, it is not clear as to whether there is a stay of the order dated 2/2/2021 as per the order of this court. This shows.
Lordship,
2/22.
there is a mistake. Maybe.
It could be because of a typographical mistake. However, on the request of learned counsel for the respondents, this matter is directed to be posted again after 4 weeks for necessary clarification.
Item 47.
May I please your lordship? There is non-compliance of order dated 4/11/22. Kindly see annexure 9, page 35.
So ID card has not been received. We'll await service report on respondent number 1.
One counsel appeared, my lord, shown in the cause list. my lord.
I'm for the respondent to lordship. 3 weeks time for filing affidavit.
She has appeared for respondent number 2. Your name?
Miss K. Burman.
Ms. K. Burman, and counsel is present for the petitioner. peruse the office note dated 22/11/2023, which indicates that service report on respondent number 1 is still awaited. Miss
P. Sutia.
P. Chutial and counsel for the respondent number 2 is present, and 3 weeks time to file affidavit. Fair enough. That the matter be listed again after 4 weeks with appropriate office note.
Item 48 for NL.
May I please, your lordship? My lord, order page number 11, my lord. Relevant portion page number 14, my lord. Last paragraph. There is an interim order, my lord. Thereafter, my lord, page.
Yes, you are applying for.
May I please, my lord? My lord, I'm on behalf of Mr. S.P. Chaudhary for NIT, my lord, for respondent number 2. My lord, as for the information that we have got, but till now the copies not sir, we don't know the content. But anyhow, my lord, some instruction is there with us, which says that there is no such steps has been taken from the part of the NIT. My lord, this has already been submitted also earlier.
My lord, in the contempt case, my lord, no notice was issued, my lord, till date, my lord. And
No steps, we'll record it and close it. That will protect your interest. What else?
my lord, in my contempt petition 1, my lord, page number 19, my lord, kindly see, my lord. My lord, how they have misguided the court, my lord. My lord, page number 19, my lord.
Yes, we'll close it. There's nothing in it.
My lord, in the read petition.
They say they will not fill up.
My lord,
All right, heard Mr. Swansol and the counsel for the petitioner, also heard Mr. S.
Yeah, K. Vishwakarma on behalf of S.P. Chaudhary.
Vishwakarma.
Respondent number 2.
Respondent number 2, yeah, for your name, Mr. K. Guge appears for respondent number 1. Alleging willful disobedience of the order dated 1/9/2023 passed by this court in WPC number 5046/2023. This contempt case has been filed. Mr. Vishwakarma has produced a copy of the written instruction dated 14/9/2023 to submit that the order of this court has been submit that there is no violation of the order of the court in as much as the NIT will not fill up the vacant position of junior assistant and senior assistant without the leave of the court. If that be so, there is no case to proceed against the petition respondents for contempt of court. By retaining a copy of the written instruction dated 14/9/2023 in the record of this case, the contempt case stands closed. Register to list the connected writ petitions for orders after 2 weeks.
Respondent number 1.
1 and 5. Okay.
I am for item number 50, my lord. Writ petition.
My lord, for item number 50, we need some time to file our
All right, it
affidavit.
will be listed after 2 weeks for orders.
Oblige, my lord.
My lord, in this case, as per office note dated 22/11, service in respect of respondent number 6 is not completed, my lord. In the meantime, my lord, we are taking steps to respond number. Six.
Sorry?
My lord, we have to take the fresh steps as per the office note, Lojima court's order in respect to the respond number 6.
You want to take fresh steps?
No.
Mr. A.R. Sigdal and counsel for the petitioner submits that his client be granted liberty to take fresh steps for service of notice upon respondent number 6. They are allowed steps by registered post with AD, making the same returnable in 4 weeks.
Lordship, it's a matter of appointment of Asha Karmi. So NHM is a necessary party to implead, Lordship.
NHM.
National Health Mission is a
In
necessary
view of
party
the
to.
submission made by Ms. D. Bora, contending that NHM is a necessary party in this writ petition. Mr. Sigdar to examine the issue and take appropriate steps for implement if so advised. List accordingly.
Well, here this notice was issued, service is complete as per the Lwajima report.
Yes, your lordship, I am for respondent number 1, 2, 3, and 4.
Four respondents.
Yes, your lordship.
So we'll have it for admission.
Yes, ma'am.
In the meantime, I am allowed to file my reply.
How much time you want?
Lordship, 4 weeks. May be here.
State Chakraborty, Learned Counsel is present for the petitioner. Mr. M. Sharma, Learned Counsel has entered appearance on behalf of all the respondents. As such, service of notice is complete in this case. Mr. Sharma has prayed for 4 weeks' time to file counter affidavit. In view of the above, register to list this matter again for admission in the second week of January 2024. In the meantime, affidavit on behalf of the respondents be brought on record.
And can I have a date, my lord?
Second week of January, what is the problem in date?
If it is,
How many days are there in second week of January?
if I get a fixed date,
And
then
what will happen?
I'll not have some
No,
other.
how many days are there in second week of January, Mr. Chakraborty?
My lord, I don't have that.
These 5 days are there, in between it will be listed. All right, let them first file the affidavit.
Lordship, in this case, your lordship, there is an infringement petition, they have filed an objection. Lordship, this matter was taken up some other day, your lordship. I could not go through the file, your lordship, I was out of state.
Mr.
29th, next week, your lordship.
29th, my lord.
Next week,
Next week.
Mr. S. Bothakul, our counsel for the applicant submits that due to some personal difficulty, he could not prepare the matter. And therefore, this IA be posted again after a week. Mr. A. Fukun, learned,
My lord, I'm for the opposite party number 11 and 12 in the IA.
counsel for the opposite party numbers 11, 12 is present and does not have any objection. In view of the above, register to list the matter after a week. Mr. And so for so. Give the appearance, please.
Keep clear.
Item 34.
Give the appearance.
My lord, in this case, affidavit is ready. We are going to file within a short time, my lord. The matter may be taken after filing that affidavit in opposition, my lord.
Mr. S. S. Shikdar, learned counsel is present for the petitioner. Mr. A. Gayal, learned CGC submits that counter affidavit on behalf of the department is ready and
Yes,
shall
ma'am.
be filed within 2 weeks from today.
Yes, ma'am.
By serving advance copy upon the petitioner's counsel. If that be so, let this matter be listed again after 3 weeks as a fixed item.
Yes, ma'am.
In the meantime, the respondents to file affidavit as per the assurance given